All right. All persons having business before the judge and Columbia Court of Appeals. Attention. God is United States and the honorable court. The honorable court and the session, please be seated and come to order.
Good morning, everybody. Welcome to the District of Columbia Court of Appeals. We have 3 cases scheduled for argument this morning. The first one is number 22 CV 548, Capital River Enterprises versus Abad. We'll begin with counsel for appellant Capital River Enterprises. Is that Mr. West?
It is, Your Honor.
Mr. West, whenever you're ready, you may proceed.
Thank you very much, Your Honor. My name is Brian West and I represent the appellants here. And they are 2 distinct different people. One, we have Hui-Yin Chang Lee, L-U-I, which is Louis. And she's an 80-year-old woman who lives in Taiwan and has not been here ever in any of these matters. We also represent an LLC by the name of Capital River Enterprises LLC, which was initially constituted by certain properties on Nicholson Street, 2 different ones. And the other members of the LLC are Napoleon, and you'll have to apologize for my inability to say his name well, but it's Ibez Ugbe, but I propose to call him Napoleon during the argument if it's all right with the court. And also Kevin Faulkner, who was also a member of the LLC. Christopher Abad, Harry Rufus, BC JCL LLC are the lenders in this case, and they are 2 distinct transactions, but they all relate to the same properties. And these are not the only transactions which Napoleon and Kevin ever did with these lenders. They have a history of doing them, and there's another pending case in the Superior Court called Benning Road, where the exact same fraud mechanism with the exact same parties followed. And that loan was those loans were over $1.5 million. Now, this is an odd case in that I've come up with a name for it, which I describe as the case of the missing. And what's missing in the case first is Ms. Liu and her disappeared membership interest. We also have missing certain documents. And when I say the disappeared interest in the property, she brought all the money to the LLC arrangement, 1.6 to buy the 2 properties. She entered into an agreement with these 2 different gentlemen. It was an operating agreement fully executed. That operating agreement was delivered to Premium Title, who's the other appellee in the case, who conducted the closings on all of these transactions. And when I say all of the transactions, these related parties, including Ms. Liu's son-in-law, did over 30 transactions there at Premium Title. They're fully informed and know about these people. And in fact, they do all the transactions that are conducted for Napoleon as well as Kevin and the other related parties. They are fully informed about the people. Now, what happens in this exercise is that we have pled that to avoid the problem that Napoleon and Kevin had, which was that the operating agreement made clear Ms. Liu had an ownership interest in the property, right, 50%. And they also knew that it was common practice and a requirement of Chicago Title, for whom Premium wrote, that in an LLC transaction, you have to have an identification of who all the members are. Now, in the files of Premium Title is the original operating agreement that lays out the membership interest. And what becomes missing, and what's missing in the record, is what other documents that Kevin and Napoleon had to present to present to Premium to meet the requirements of the underwriting, which was that you have all these documents identifying the membership interest. And our position is that all that those people at Premium had to do was type in the record named Nicholson Lane and the 2 property addresses, and it would automatically populate all the old files that they had.
I mean, that sounds like it gets you to a claim of negligence against the title company, but it doesn't sound to me like it gets you to the title is void.
I agree with you.
Yeah, so explain to me But your principal contention in your case, or at least your lead contention of the brief, is the whole deed of trust is void because underlying it was a doctored document. Is that right?
That's right. The LLC agreement, which we understand to have been presented. We don't have it. It's not in the record. The appellees didn't produce it below when they filed their motions to dismiss and also their motion for summary judgment.
I'm sorry, what wasn't, are you saying the operating agreement that they relied upon has not been
That's right.
presented? Can I ask what your good faith basis is for saying that it was doctored?
First, that my client had communications with Napoleon as well as Kevin, and that they related that it was in fact a modified agreement that did not take into account Ms. Liu's interest. That's what our basis is. And we maintain it that it is a forged document as well in the pleading, because they would have had to sign something, and whether or not they signed a conveyance of Ms. Liu's interest to explain why she no longer was in the deck or not, I can't tell you because they didn't provide it to us.
I suppose what the reason why I asked the question is because under the accurate operating agreement, the true operating agreement, nothing stopped Napoleon and Kevin from taking out this loan. They were two of the three. The operating agreement requires a 2/3 vote of the membership. They were that, so they had the right to take out the loan against the property anyway, right?
I think under the MOU, they certainly
Under the
would
MOU.
have the authority to take out the loan. Well, our position is that we should be able to put on evidence concerning their understanding between my client and them, that they did not have such a right, that they never were intending to have such a right. And the way they attempted to construct these agreements without an attorney was to, in fact, be able to assure that nothing like this could occur. And I think we should be able to offer evidence also to support the view that if you read both of the two documents that we claim should be operative, that there is no mention of a loan anywhere in any of the documents, and or taking a loan or an indenture or issuing a deed of trust or any of those normal.
But there's mention of major decisions, right?
True.
And taking out a loan against the property certainly sounds like a major decision.
I would agree with you. It does sound that way. I think the point that I'm attempting to make is that if you thought that was a major decision, that's one of the most major of all decisions you could take, which would be to labor the property itself with a loan. And you would lay out in that document itself how you would go about doing such a thing if you even contemplated it. And the reason this is germane here is that Ms. Liu was the financier. She had the money. She put the money up to purchase the property. There was no loan involved in this at all. There's no authorizing language in the actual operating agreement talking about how you would go about taking a loan. And we all agree, if that was a really major decision, you would make some mention of it, because you can see in all these documents we filed, they're all talking about what happens in the events of default, if you have to exercise certain authorities. They have no mention of that. So,
That is true, although the record leaves one with the impression that the money Ms. Liu put up was for the purchase price of the property, although I'm not sure the record says that.
think it
And
does say-
then it refers to what Kevin and Napoleon were contributing, which seems to be their expertise with respect to development. And when you think of development, at least I start to think about loans to finance the development. So it's not surprising that one could think that a major decision would include a taking out a loan, offering the property as collateral.
perfectly.
Is there anything in the
There's something
record that actually tells us what they did with the money? I realize that's not the issue before us.
Oh, there is. There's
Maybe.
a closing statement that I believe is attached to the complaint where the transaction itself, where the loan was distributed to Napoleon and Kevin. So it's the closing on the
Right,
loans.
but
That shows that where the money was sent.
well, I noticed that, but it seems to me one could take the money obtained through a financing like that, put it in his own bank account and use it to develop the property. There's nothing necessarily
I don't
improper
disagree.
about that.
I don't disagree with you. You could make that direction, but I was just answering your question. That's where it says that where the money went. And I don't think there's a dispute that it went to them individually. And certainly we're talking about red flags coming out. Right. So this is, and I'll come back to finishing your question about whether or not the motion to dismiss should be granted because they're forged documents. Well, the record before you is that no LLC agreement was presented to the court that, at least that we've seen, right? And instead they're reviewing the MOU itself. And I have no idea what this missing document actually would show, the one that was presented. And I don't know what they said. And if you were concerned about getting rid of Ms. Liu, you would need to have her sign off on her interest. And if you were reasonable.
I mean, not under the MOU though.
Pardon me?
Why? Why under the MOU?
To convey your interest?
Why under the MOU? Why can't, when it says that 2/3 of them get to make major
To
decisions,
convey her interest?
not to convey her, I mean.
No, I'm saying she would still be in the LLC, right? And if that wasn't the case, you would, if you were coming to buy this piece of property and go through closing, and the closing had to be presented on the documents, they say, what happened to Ms. Liu? Because we know that she was the 50% interest. That document was not presented to the at the time of the closing. That document was not presented to the judge to make the determination that it was consistent with the two, that that document is the issue. Right, so that is the missing document here. If they had presented the actual LLC operating agreement, they would know about Ms. Liu. They would know that her interest was not addressed in the new operating agreement. We understand went 90-10, Napoleon and Kevin, but she's missing and she never signs off on her interest. And one could reasonably say that how would everybody know about this? It's because the title company had the actual document in its files. And it's not like the old days, you have to go off to another storage facility. It's on their computer. It would have shown them and it would have done something else. First, it wouldn't allow them to close the deal. Two, it would be germane to both of their principals who they owe duties to. They would have been able to and required to tell Capital River and Ms. Liu that her interest was being removed and disregarded and that she was apparently no longer had an interest. And they would have to tell the lenders because one could bet if they knew that Ms. Liu was disappeared as that she was, that when she found out, they would be sued in a case just like this. Right? It is.
I can see how all of this possibly supports your claims for conspiracy and the underlying torts, tortious interference and slander of title, negligence. I think I covered them all, but I'm back to Judge Deal's question about your claim that the transaction was void. I know you rely on the language in Smith v. Wells Fargo Bank about documents relating to the property, which probably was an unfortunately broad statement in that case. It was clear that what was involved in that case was a power of attorney. So documents relating to the property envisioned the document that authorized someone to sign a deed or didn't, the power of attorney, and the deed itself. You now are trying to have that term sweep into its fold a forged operating agreement or forged MOU or wherever it is. And I'm just thinking that the holding of Smith v. Wells Fargo doesn't go that far. Why do you think it does?
I'm sorry, your question poses the idea that it would be reasonable to require included in the documents which can void a deed of trust being granted against a piece of property are those documents which provide the authority for the individual to sign, such as power of attorney, right? That is the actual grant of authority. It isn't a deed, it isn't a deed of trust. It's instead a part of the transaction authorizing the individual. Our position is that the LLC document itself provides the authority for members to do certain things. And that just like the power of attorney, this is a core document which is establishing the right of the grantor to actually sign. And if you don't have that document, you cannot conduct the closing. I'm sorry.
I mean, I think part of their response is, but the actual operating agreement, the true operating agreement still would have allowed the transaction to go forward. So it's not like, I mean, it would be one thing if a power of attorney were entirely doctored. It would be another if somebody brought in, a photocopy of the power of attorney, and what the title company usually requires is the original, but they went and worked with the photocopy of it. I doubt we would apply Smith v. Wells Fargo to that scenario, just like I don't understand why we would apply it here. I think under your theory, which partly alleges a conspiracy, even if the title company knew, even if the lenders knew that this was a doctored document, and they would have accepted the true one as well, the transaction would still be void. And that doesn't make a lot of sense to me.
Well, I think maybe it's a circular problem they have, which is, why are you doing it? And no one speaks to the answer to that question. If you in fact had all the authority to do this, if you wished, and you knew you did, why would you doctor a document? Why would you forge a document?
Well, I mean, that's part of my question. I don't mean to cut you off, but part of my question, when I got to why do you have a good faith basis to say they doctored it, is if your whole theory is this is a conspiracy, the title company, you know, they're in on it, the escrow agents are in on it. Why would they even bother with the doctored document?
Oh, I think that is a robust question here, and there is an answer, I think, in which is that they all knew that the title company would not close on the property if they had it presented to them. So in the moment, they're in a willful blindness position. I don't remember, we don't have that available, but they did have the original operating agreement. But the real problem is that Chicago Title would not allow them to close the loan and issue title insurance on the property if all of the members' interests are not addressed. This is a standard of care issue at one level, but it does go to the law in that that is the way it works. You need to be assured whether or not their documents allow them to do it or not. Chicago Title isn't going to stand for the transaction and requires all the members to be identified. And now when you look and see the other individual, and you now are on inquiry notice, right? Well, what happened to Ms. Liu? And the title company in the ordinary course would be required to do that and find out. And when they found out she hadn't signed off on it, they would inform Capital River as well as the lenders so that they would know that they're buying off on a piece of litigation because the missing member. And if you read the document which we provided, which is from Chicago, it's in all LLC transactions they were required to do it. And they have violated that provision. And if we accept the conspiracy argument, then they all knew, but they may have willfully not looked at the initial operating agreement, or conversely, at the end of the day, they knew they would not be able to conclude the transaction as written because of the title insurance requirement. And there's a reason people do things. And the question about what the reason might be, I suggest to you, is germane in the question first of granting the motion to dismiss, because all of the allegations I make in my complaint are presumed true.
So counsel, help me with this, and I'm not dismissing your argument at all. A lot of what you say makes great sense to me. If they didn't have the ability on the underlying operating agreement, MOU, et cetera, to go forward, why'd Ms. Liu amend it later with them?
Oh, very much can explain to you. And we're back again now to the overarching question of why to do things if you don't have a legal obligation to do it. So that's the starting and ending position for your questions and for my opponents, which is under the MOU, they could have done it anyways. There's a reason they didn't, is because there are implications to the transaction itself. In this circumstance, Ms. Liu, because of being treated ill under the state of the documents as they existed at the time, in that she had lost about $2.5 million to these group of individuals, did not want there to be any question about the fact that this was not allowed. But more importantly, she wanted the concessions that were contained in the document itself by Napoleon and Kevin saying, we didn't have authority to do what we did, right? That's why we're agreeing to do it. It expressly says those things. So if there is a quid pro quo that's going on here in executing the amended document, well, if we think about it from Napoleon's point of view, maybe she won't call the FBI. Maybe I won't get sued. Maybe we'll be okay. And from her point of view, I don't want this to happen ever again. But more importantly, I want you to admit and confess that what you did was illegal and you didn't have authority to do it and you knew it. Right. And so one of the questions we keep coming back to the motion to dismiss for a reason, and aren't talking much about the motion for summary judgment, which I will in whatever time I have. But the real problem here in this is that all of this is based on the assumption, and the law is based on an assumption here, that people had information available to them and they made reasonable decisions based upon the information. But we don't have that, right? But we do have lots of weird things, like where is the missing information? Why don't you go and look in your file? If they've been doing deals with these people and they know they never own buildings free and clear because they weren't the purchaser, all this does is creates inquiry notice, right? And the reason I'm speaking to notice in this is because the basic argument that's made by the court below in its decision is because the documents availed them of that power that that because the MOU said what it says, then it doesn't matter, right? But if we have these items that point to inquiry notice, you're not allowed to have willful blindness.
I guess
they
just one
would-
more before we let you address summary judgment. I have one other question, which is under your theory, Abad and Rupes could have been totally blind to all of this, and you still say the transaction would be void. If somebody had presented them with a doctored document, even if they had the authority to enter into the loan agreement underneath the appropriate document, then the lender would be out of luck. That is a pretty surprising result. And I understand that we have accepted that result with regard to powers of attorney and with regard to actual forged deeds of trust. But we've never extended it beyond, and I'm unaware of any court that's extended it beyond that discrete area, just to any old thing that might have been doctored and underlaid the agreement. And it strikes me as quite surprising. So why do you think that's a sensible rule? And do you have any cases that have extended it beyond the power of attorney / forged deed of trust context?
Well, not out of that context. I mean, the ones that we've cited to you in the brief are indicative of people accepting in the LLC area that forged document has impact in it. But is a general statement of law, is it reasonable that if you think about in the Wells Fargo case, we're talking about innocent purchaser for value, right? That affords you a defense, right? But that's in that secondary market. This is an original issuance. But if you think about why the system would be the way it is and placing risk of loss in a rather perhaps unfair way to that person because he didn't know or wouldn't have reason to know. But it is exactly this. It has to do with real estate. Real estate is particularly important. It's unique. And we're very much worried about people losing title to their property, right? And because of some fraud that happens that the lender might not have known about. And if you're going to place where the risk, generally, I think at an institutional level, we think of lenders as larger institutions who are in that business of lending money back and forth. And we have the people who have bought property, they took their hard-earned savings and they put it in purchase. So if you're going to balance the risk of loss, where should it be? Should it be the bank or should it be the consumer? And would be a reasonable decision, perhaps the risk of loss ought to go to the bank. And what would further that argument is the fact that all of these real estate transactions require title insurance. And what is title insurance first issue that they're insuring around? They're insuring around fraud, forgeries, and other aspects about the execution of the documents. And if you think about what this really is all based on, is a system that you should be able to rely upon the information that you're given and when you go to the closing to make the decision buy or sell. And what the insurance title company is doing, Chicago, I'm sorry, is doing is listing as things of minimum requirements, but that it meet that need, which is to know that the people are who they say they are, that the person who has the piece of real estate that they're attempting to either get a loan against or sell, own the property and the ability to do it. And because if we don't do it that way, that everybody seizes, right? So the reason title insurance stands is it is a salve to the problems of trust that go on in a closing. And that is in fact what they do. And that's why they are paid for what is effectively adjunct malpractice insurance. That's the issue they insure. And when you look at this, it's like, generally we don't talk about insurance a lot, but in the continuum of real estate transactions themselves is a central core piece. That is the person who's ensuring that it's all done right. That's why all these people are here, right?
Counsel, if you want, I mean, you've been out of time for a bit, but if you want to spend just a minute or two talking about addressing the summary judgment ruling, we'll give you a minute or two to do that as well.
Yes, Your Honor. There are two issues that go along together with each other. I got no discovery. This is a very odd case. I should have been entitled to discovery. They never should have granted the motion to dismiss because there are certainly issues outstanding about the missing document, the missing person, in fact, if all the parties are there that are necessary. As far as the summary judgment motion, they haven't been able to put on evidence of any way that would show that one, premium was not negligent. We've made a good faith allegations in the complaint that set forth that they closed this transaction based on forged and fraudulent documents, that they had the information in their possession, that they didn't review it, or if they did review it, they're willfully blind of it. And we went through, I think, 12 different breaches of the standard of care when it came to this real estate transaction. And I've not heard a reason yet from the other side as why they're not negligent, why it was reasonable for them to close the transaction the way they did without looking at it, right? Without at least doing the assurance of what you and I would do if we had just closed that property 2 years ago. I'm going to get the file. And the most important reason is I can do a title bring down, which is much less expensive than if I go do a full title search. That's why they all use the same closing companies, because they have their documents and things. I submit to you that in this case, when they had that information and they didn't use it or willfully were blind to it and caused the loss that my client encountered, which is almost $1 million, not including the attorney's fees, that on that set of facts, you would be entitled to put on evidence in support of this position. And based on the allegations, I at a minimum should have been allowed to go and seek discovery to find out what those documents were in the file, which also speaks to the motion to dismiss. What did they actually close on? They wouldn't give it to us. I don't know, right? And the next is, the rule is simple: unless there's no issue of material fact in dispute and that the defendant is entitled to judgment as a matter of law, you can't grant a summary judgment motion. And how is it at all fair that we not have an opportunity to actually prepare our case, go obtain the documents, inquire about the relationships between the parties in the conspiracy ideal? I didn't get to talk to anybody. I wasn't allowed to take a deposition of a single soul. The motion to dismiss was granted like that, and I didn't get anything, and we're left there. And she didn't grant us an opportunity to replead. If I had discovery, who knows what we would have found when it came down to that one issue. And if you've seen, all the law requires is for me, if I want to avoid a dismissal of a motion for quiet title, is to claim I own title. That's the law. That's all I need to show, is that I claim I own title to the property. And I can, it's
Did
cited
you
in a-
tell the Superior Court in one of your papers that you needed discovery?
Well, we certainly did tell Superior Court we needed discovery. It was unreasonable for them to grant this summary judgment without having the opportunity to do it. I think it is in the summary judgment motions where that was laid out. I don't think I laid that out in the motion in opposition to the motion to dismiss. And the reason is that I believe, from the way the law states, is that the motion in this case, it is rarely granted a motion to dismiss. And the reason is my pleading requirement is only to make out a case which I'm entitled to. I don't have to win my case there. I have to make out a good faith claim that I have in a reasonable amount of detail, but not great detail.
Right, and I was
Succinct
really
statement.
asking about your paper filed in opposition to the motion for summary judgment.
Right, we did file in the opposition. to the motion
And
for
I believe there was a footnote saying you haven't had discovery and that you were entitled to discovery in that.
That's right. And so I think in this case, they can't win in summary judgment in a normal application of the law because I'm entitled to put on my case to do discovery. The rule itself, 56C, says I should be entitled to discovery before the summary judgment motion is granted. And I don't see how I can reasonably have been expected to put on this case where I've alleged fraud and I've alleged all of these other malfeasances and basically malpractice in the closing of it. This is a negligent case. This court has said repeatedly, it's extraordinarily rare that you grant summary judgment in a negligence case because that's the purpose of the jury. The court certainly has a determination power as to the existence of a duty, but it doesn't have control on whether the standard of care is violated. Standard of care is a province of the jury.
All right, counsel. We'll give you a few minutes, unless my colleagues have any further questions. We'll give you a few minutes on rebuttal still.
Thank you very
And
much.
we'll now hear for counsel for the appellees. I believe first up is Mr. Bressi, is that correct?
Yes, sir.
And Mr. Bressi, could you just state for the record both your name, who you represent, and how you plan to divide time among the appellees?
Certainly, Your Honor. May it please the court, Nathan Brzee for appellees and lenders, Harry Rufus, Christopher Abod, and BC JCL LLC. Regarding the timing and order of the arguments, the lenders will divide their time equally between the lenders and premium title. So each side will have 7 or 8 minutes to present. Lenders will go first, obviously, and I will present first for the lenders for about 5 minutes, solely as to count 1, which is the quiet title count. The remaining counts against the lenders will be addressed by Joseph Creed, who is remote. He is counsel for Mr. Rufus and Mr. Abod, and by David Panzer, who is here, and he is counsel for BCJCL LLC, and they're the beneficiary of the second deed of trust. Initially, I did want to address one statement of appellant's counsel that he made near the end of his argument. And that statement was that in order to overcome a motion to dismiss in a quiet title action, all the plaintiff needs to allege is that they have title. And that's from the Kemp versus Island case. It's cited in their brief. What appellant's counsel left out is the next line of that opinion, which states that there must be specific allegations to support a quiet title action that are factually supported and sufficient to challenge the documents that actually encumber title. So it's not enough to just simply allege you have title. The allegations of the complaint must be specifically made, and there must be a sufficient basis to challenge the documents that actually encumber title. And we submit the plaintiffs and the appellants in this case have not done that. Generally, regarding the substance of appellant's case, in listening to appellant's arguments and in reading appellant's brief, I'm reminded of the traditional maxim of equity that states that one who seeks equity must do equity. And here, the appellants are seeking extraordinary equitable relief, and they're seeking to void a deed of trust that's been executed, certified, acknowledged, and recorded. And as this court has stated numerous times in numerous cases, a deed, and by extension, a deed of trust, is among the most solemn instruments known to the law. And a litigant who seeks to overcome a deed or a deed of trust and void those documents faces a very high burden to do so. And even though appellants are coming to this court asking it to do extraordinary equitable relief, there's nothing equitable about the relief that appellants are seeking here. I mean, in seeking to void these deeds of trust, what appellants are essentially doing is seeking to avoid the consequences of the governing documents of the LLC that Ms. Liu, appellant Liu, herself agreed to and executed. So regarding the other arguments of appellants.
Well, counsel, before you go further, I'm a bit amenable to the idea of your friend on the other side that, you know, they don't know, they didn't get discovery, they don't know what was reviewed by any of the parties, and clearly this goes mostly towards the title company. But did your clients get to review that operating agreement and that MOU?
And Your Honor, they of course reviewed. The answer is I don't know the answer to that question, but the answer is it doesn't matter essentially what they did review. The question, at least as to count 1, is the deed of trust, are the 2 deeds of trust valid under DC law? And in order to be valid, they must be executed, they must be acknowledged, they must be certified. And as to third parties, they must be recorded. And with regard to the execution of the deed of trust, the question before this court is did Mr. I.B. Zugby and Mr. Faulkner have actual authority to execute the deed of trust. And it is undisputed, and appellant's counsel does not dispute, that under the terms of the MOU and the operating agreement, they did have actual authority as 2 out of the 3 members to make major decisions for the LLC. And by executing the deed of trust, they executed their authority to make a major decision and to encumber the property. So moving on to the other arguments of appellant's counsel.
I mean, what if they had done so under extreme duress? Let's say that somebody signed a deed of trust while being held at gunpoint. Say, go ahead, title company, escrow agent, prepare all the proper paperwork, or this is going to end badly for you. I assume you would say that is not a valid deed of trust, right?
That is an interesting hypothetical.
Well, I suppose, how far away is it from if the deed of trust were procured through a blatant fraud?
Well, as the court asked the appellant's counsel, the only case they rely on that would indicate or tend to indicate that a supposed fraudulent document executed in connection with the execution of a deed or a deed of trust is Smith versus Wells Fargo. And they rely specifically on just one line of dicta in that case that states essentially that a party cannot acquire an interest in real property through a forged instrument related to that real property. And as the court pointed out in its questions to appellant's counsel, that case really goes to powers of attorney, specifically powers of attorney, because District of Columbia law treats powers of attorney, especially powers of attorney that convey interest in real property, as really unique instruments under the law. And it's strictly controlled by statute. And that statute is DC Code 21-2603.03. And that statute states that powers of attorney must be executed in the same manner as a deed. They must be recorded at the same time or immediately before a deed is recorded. And as the court knows, there's actually specific language the power of attorney has to state at the top in bold in order to use the power of attorney to convey real property. And there's no requirements like that for an operating agreement. There's no requirement that an operating agreement be certified or executed in the same manner as a deed or recorded. There's no requirement under the law that an operating agreement even be displayed or disclosed at the time property is conveyed either to a grantee or to a lender. That may be what is ordinarily done, but there's certainly no requirement to make the deed of trust valid. I mean, the fact that, and as the court addressed with appellant's counsel, the fact that Mr. I.B. Zugby and Mr. Faulkner may have presented an altered operating agreement at the time the LLC executed the deeds of trust does not make the deeds of trust void or voidable. In the relevant issue is the actual authority of Mr. I.B. Zugby and Mr. Faulkner provided by the governing documents, again, that Ms. Liu, appellant Liu herself agreed to. And here the trial court properly examined the actual language of the MOU. And that's at page 144 of the appendix. And not the language that appellants would like the document to have, not the language that they alleged in their original complaint, but
So,
the actual
counsel,
language of the MOU.
regardless of what your clients knew at the time or what they saw when the deal was done, you're essentially saying that based on the actual authority of what the trial court saw, that it would be akin to harmless error, and that's all we should focus on.
The proper focus of this court, when it comes to count 1, and the other counts of the complaint as against the lenders can be addressed by co-counsel. But the proper analysis for this court under count 1 is was the deed of trust properly executed under DC law? The 2 deeds of trust. And again, to be properly executed under DC law, it must be executed and certified and acknowledged and then recorded. Again, appellants face a very high bar in doing so, and attempting to void these deeds of trust. And if the court, by affirming, all the court is doing is enforcing the operating agreement and the MOU that, again, that Appellant Lou herself agreed to.
Counsel, because you appellees are splitting their time 4 ways, I'm going to be a little restrictive with those time requirements. I think we'll, unless you have a final thought or my colleagues have any questions, we will move on to the next counsel.
Thank you, Your Honor.
And am I right that Mr. Creed is proceeding next?
Yes, Your Honor. Thank you. May it please the court, Joseph Creed on behalf of appellees Christopher Abad and Harry Rupus as to the claims for intentional torts, which are counts 3, 4, and 5 of the complaint. The court should affirm the dismissal of counts 3, 4, and 5, really for the same reasons that Mr. Breese just explained. Now, appellants really don't address these claims directly in their brief, but the Superior Court dismissed these counts for the same reason that it dismissed count 1. Mr. Igbuzi and Mr. Faulkner had actual authority to engage in this transaction, to take out the loans, to agree to the deeds of trust. And because they had the authority to do that, it cannot possibly be that the lenders committed an intentional tort in granting that loan and accepting the deeds of trust.
I don't understand why not. Explain that to me. So if they had the authority to take out a loan against the property, but in due course, Ms. Lou would have been notified before that happened. Ms. Lou might have had a variety of mechanisms to prevent it from happening, or maybe the title company itself above the agents wouldn't have allowed it to proceed. So if they engage in a conspiracy and behind the scenes say, look, we're going to make sure that doesn't happen, that Ms. Lou never finds out anything about it. And if that is also negligent to act that way, if it is against what the title company normally does, who cares if they had authority to do it anyway? That seems to make out claims of negligence. It seems to make up claims of civil conspiracy and maybe tortious interference with a business relationship. Why do you think that's wrong?
Well, the reason, Your Honor, first of all, as to the negligence, there's not a negligence count against the lender.
That's as for premium title, of course, yes.
Exactly, Your Honor. So that's a completely separate issue in terms of whether the title company was negligent. And I won't address that issue because it doesn't involve my clients. But in terms
but the question is, if your clients agreed with, I think we're referring to them as Kevin and Napoleon, to cut Miss Lou out of the loop, make sure she doesn't find anything else out about this, because if she knew, she'd have some recourse. If that's what happened, why doesn't that make out a civil conspiracy or tortious interference claim?
Well, first of all, Your Honor, it doesn't make out a civil conspiracy claim because there has to be some underlying unlawful act that the parties conspired to do. And if Kevin and
presenting a doctored document to the title company that they otherwise wouldn't have accepted had they known what the real operating agreement was.
Well, in here, there would have to be facts pled in the complaint that the lenders knew that there was a altered operating agreement and that they had an agreement with the borrowers to present that altered operating agreement to the title company.
I understood that to be pled. Sorry.
I'm sorry, I was just going to say what the complaint alleges is that the lenders had prior relationships with Napoleon and Kevin because they had done a number of deals together, and upon information and belief, it says the lenders may be complicit in Napoleon's and Kevin's scheme from which they all benefit. In other words, the allegations are that the lenders were not innocents who relied upon an MOU that gave these two actors authority over major decisions, but they were individuals who knew that these two actors were going around doing inappropriate things with respect to a number of deals, and they participated in it anyway. Now, that may not be true, but why wasn't that enough to get past the motion to dismiss or a motion for summary judgment where there'd been no discovery?
Well, Your Honor, the allegations are that information was provided to the title company. With respect to the lenders, the allegations are upon information and belief. it's simply, it's a leap. There are not any facts pled in this complaint as to what the lenders had knowledge of, and there aren't facts that would give rise to a reasonable inference that the lenders had knowledge that something improper was happening. The allegation that they had done prior loans with these borrowers certainly doesn't give rise to that inference, because there's no allegation that those prior loans resulted in any case like we have here today, or that there was any evidence of fraud or any wrongdoing in those prior transactions. So if anything, that would give a reasonable inference to the opposite of what the plaintiffs are claiming in this case. And the
I don't
lenders would
think
have had
the
no
case
reason-
was dismissed, though, on the reasoning that there was no plausible claim here, that the Iqbal Twombly standard wasn't met. It seemed to all turn on what the MOU authorized Kevin and Napoleon to do.
And that's correct, Your Honor. And I think we have to go back to the elements of the torts that were pled against Mr. Abad and Mr. Rupus. Okay, setting aside the title company, because what was pled was a tortious interference with business relation. And in order for that claim to survive, there would have to be factual allegations, or at least some reasonable inference that these lenders intentionally interfered with a business relationship or with a contract. But what the facts show under the MOU is that the contract and the business relationship actually authorized these borrowers to take out this loan and encumber the property. So if they had the authority contractually to do that, and the deeds of trust are valid, which they are, then it couldn't possibly be a tortious interference. They weren't interfering with the contract. The loans are consistent with the contract. And so that's why I say, Your Honor, that it can't possibly be that the loan is good, the deeds of trust are valid, but somehow it was a tort for the lender to have issued that loan and accepted the deeds of trust. And the same is true of the civil conspiracy claim. And that's why the Superior Court got it right here. Because if the underlying transaction is valid and consistent with the contract, then it can't at the same time be an independent wrong that these parties somehow conspired to engage in. And so,
Do you think anything about the MOU says that Kevin and Napoleon could take the money and directly funnel it to their personal bank accounts, as opposed to using it for the benefit of the LLC?
well, Your Honor, I don't
Do you think that's a major decision on behalf of the LLC, or do you think that would be considered a fraud or a tort against the LLC to do that?
Well, I don't know whether that would be considered a major decision or a fraud or a tort, Your Honor. It would depend on what the purpose of the loan was. And there's no requirement or obligation on the part of the lender to police the borrower in terms of what they do with the proceeds from the loan.
Yeah, but this is not like a duty of care type claim. It's not that you had a duty to police the borrowers. The claim is you were in on it with them. And at a motion to dismiss stage, where there's no factual development, and they've got, it doesn't strike me as entirely implausible.
Your Honor, and I think based on the allegations in this complaint, that's really the issue. Okay, there's not facts here from which a court can find or infer that the lenders were in on it. That's really the issue. That's the leap that they're trying to make here in terms of pulling the lenders into it. And in regard to the point that Your Honor just made, it seems to be that the crux of this case is that Kevin and Napoleon took out this loan, and the allegation is they used it for their own purposes, for some personal benefit to them and not for the LLC. And assuming that to be true, that is a wrong by Kevin and Napoleon against the LLC and against Miss Liu. And her remedy and her claim is against Kevin and Napoleon to recover those damages on behalf of those parties. What they're really trying to do is shift that loss to the lenders, who really are the most innocent parties here, because all they did was grant a loan secured by the property, consistent with the authority of these two members. And going back to what Mr. Bresee just said in his argument, really the question as to count one, and I think it's the same question as to the other counts. When Capital River entered into this loan transaction, the LLC as the borrower, did the individuals who entered into that transaction and signed off on behalf of the LLC have authority to do that. And that's really the focus of the question as far as the lenders. And if they did, which they did, then it can't also be that that loan was a tort against the LLC that was borrowing the funds.
Well, Mr. Creed, let me pose the question to you as well then. Do we care about what your clients knew at the time? Is that when we're looking at the actual authority as it was established then? Or are we looking at it, which your opposing counsel says we don't have any discovery on, no one knows for sure, that hasn't been represented? Or are we looking at it solely based on the documents that we know came in front of the trial court at that time?
Your Honor, we're basing it on the documents that existed that authorized Kevin and Napoleon to enter into this loan.
Do we know that your clients knew of those documents' existence and that that is what they relied on when they did that? Or does it just matter that they exist, period, is the question?
It only matters that they exist, period, based on the facts that are pled in this complaint and the allegations in this complaint. Now, the record doesn't answer Your Honor's question because this came up on the pleading and went out on a motion to dismiss. But we're basing this on the allegations in the complaint. And the allegations in the complaint do not cross the threshold into plausibility beyond speculation when it comes to the lenders. It doesn't, these allegations do not cross that threshold. And for that reason, it was proper to dismiss the intentional tort claims.
Well, the complaint says that your clients not only were familiar with Napoleon and Kevin, but they acquired interests in another property on Benning Road that involved a couple of deeds of trust that secured loans for more than $1.5 million. Now, again, maybe that's not maybe that was not inappropriate. Maybe it's not even true. But I'm not sure you've persuaded me that that allegation was not enough to nudge this complaint across the line such that it could survive a motion to dismiss. Seems to me some discovery is needed in this case.
And if I could just address that point, Your Honor. The allegation in the complaint, and I think you're looking at paragraph 52 of the complaint.
I am, yes.
Is that there is another property where there's a similar dispute. And so, and that is happening in a separate matter. But again, that doesn't create any plausibility with respect to the knowledge or intent or involvement or complicity of the lenders. It's really no different than the scenario we have here, particularly when you couple it with the allegation that there were prior transactions with these borrowers. Okay, and there's no allegation that any of those allegedly numerous prior transactions involved any fraud or any litigation. And so really, what the complaint says that there were a number of prior transactions with no issue, and now there's been 2 transactions where Ms. Liu is disputing this very thing in terms of their authority under the MOU. That does not cross the threshold into saying that the lenders were involved or complicit or conspired in any way in the underlying alleged wrongful conduct, which again, the underlying alleged wrong is not that they lacked authority for the loan. I think it's undisputed that under the MOU, they had authority to take out the loan. The allegation is that they took the money and used it for some wrongful purpose. And there are not facts in this complaint that say or suggest that these lenders were involved in that in any way or even knew about it.
Okay, counsel, unless my colleagues have further questions, we will hear from Mr. Panzier.
Thank you.
Morning, Your Honors. David Panzer on behalf of BCJCL, the second trust lender. Your Honors, I'm not going to repeat what my colleagues have said. I'm prepared to answer some questions. Judge Thompson, I would like to come back to your point with respect to the additional fact regarding the second property. My client was not involved in that. So the distinction between upholding a motion to dismiss turns on that fact that there's a separate transaction involving another property with respect to Ms. Liu, that does not exist for my client. And one of the things that
Your client again,
my client is BCJCL,
BC, right?
which is the second tier lender. One of the things that's important about that is that we've heard that there were a number of prior transactions, but none of those prior transactions involve Ms. Liu, and the complaint doesn't allege that it does. And so, Judge Deal, if we come back to your hypothetical, you said, what if there's a scenario in which the lenders had no idea that there was somebody else out there. And now, and they have no idea that there's a forgery that's been presented to them. We've never had a case in the DC Court of Appeals where we have turned over a deed of trust. And again, I'll reference what Mr. Breezy's argument was. He pointed to the DC statute that explains why a power of attorney is different than any other document that might be fraudulent or might be forged. Judge Howard, I'm prepared to answer one of your questions. Before I do so, it would require me to give you information that's outside the record. So if you'd like me to answer the questions about what my client knew, I'm happy to do so. Sure. So Your Honor, my clients received an operating agreement that looked like a real operating agreement and had it involved Napoleon and it involved Kevin, and it didn't have any mention of Ms. Liu. Now, my recollection, and I could be wrong, is that I provided a copy of that to Crawford at the inception of the case. I don't have a recollection of that one way or the other, but that so that's the scenario we're in. We're in a scenario where you have small individual lenders that are operating in in commercial practice. They're presented with a document that appears appropriate. It goes through the title company that checks or doesn't check what it's supposed to do. It's supported by title insurance, and my client's out a bunch of money. And so I'm not sure what the conspiracy would be. In this case, there doesn't appear to be any conspiracy or other torts alleged that are outside of the construct of a proper loan.
I think part of what's troubling me is, the trial court's analysis, and I think Judge Thompson pointed this out, the trial court's analysis in granting the motion to dismiss doesn't really sound like the defense that you're giving to it. One thing the trial court could have said is, well, as to BJ DCL, I'm so sorry if I'm getting the letters wrong. Well, there's really no evidence they had prior relationship with Kevin and Napoleon. There's no reason to think they're in cahoots with them. And so they haven't stated a plausible claim for relief. Motion granted. Motion to dismiss granted. Instead, what they said is, well, Kevin and Napoleon could have taken this loan out, and therefore you can't have tortious interference. Therefore, you can't have conspiracy, which strikes me as almost certainly wrong as a legal matter, because I can imagine all sorts of ways that somebody could have a legal right to do something and yet tortiously keep somebody else with an interest in that something in the dark so that they couldn't seek their own remedies. So I wonder what we ought to do with that. I mean, if I think you're probably right, do you think we should take those questions sort of in the first instance, that we should look at the complaint and answer for ourselves whether or not, even if we think there was authority to enter into this loan, that there was, even if we think that doesn't provide an absolute defense against these torts, still we don't think there's a plausible claim? Or should we send that back to the trial court for its consideration, having been disabused of a ruling that we think might be wrong?
So,
sorry, that was a mouthful, I know.
Well, Your Honor, I mean, you're talking about the sufficiency of the complaint, and I think that's a question that the Court of Appeals can look at the same way the trial court can look at. There's no fact finding that goes with it. With respect to the sufficiency of the complaint itself, the only there are certainly direct allegations as to premium title, and I'm not going to argue as to whether the case should go back on a negligence basis for premium title. My client has no interest in that. But before ever since Twombly and Iqbal, we don't allow allegations on information and belief without any further factual support to address torts, particularly, and there are reasons for that. I mean, certainly with respect to fraud, there's a heightened pleading standard, but the policy reason for that is just having to go to trial on a tort plan, one that talks about slander of title, one that talks about interference with business relation, has reputational harm, and you don't get past the first stage unless you have some factual allegations for that. And here, perhaps there might be allegations, involving, the first lender, but if there's another property involving Mrs. Liu, Perhaps if there was some reason to believe that my client was in cahoots with somebody else, but that's none of that is here. So you're left with a complaint that was not sufficient. And then the judge is looking at it presumably from the perspective of, well, should I give leave to amend? And at that point, you're left with the sort of the secondary defense, which is what was done by Kevin and Napoleon was authorized authorized by the actual MOU. I had a case like this, many years ago, also representing a lender, where a grandfather wanted to help out his grandson. And so the grandfather, took out a loan against his commercial property, took it out from the bank. The bank, turned over the loan, $100,000 or whatever, put it in the joint account of the borrowers, the grandfather and the grandson. Then the grandson ran off the money. It's terrible. But that was a claim as between the grandfather and the grandson. And so Judge Thompson, this comes back to your point. Couldn't Kevin and Napoleon, under the actual operating agreement, have borrowed the money, put the money into their own pockets, and then used it to develop the property? Sure. And in the event that they then didn't use the money to develop the property, but used it for their own personal gain, that's a suit as between Kevin and Napoleon and Ms. Liu. But here we are arguing, and Ms. Liu has never been in proceedings, and Kevin and Napoleon have never been in proceedings. And instead, I'm representing a lender who offered, who lent, $375,000 years ago to some people who are alleged to have done some really bad things. And my client's deed of trust they're arguing to strike it, even though the people who took out the loan were authorized, in fact, to take out the loan and to burden the property that they burdened.
Okay, counsel, unless my colleagues have any questions, we will hear from Mr. Ritchie. I believe, Mr. Ritchie, you have 7 minutes.
May it please the court, Spencer Ritchie on behalf of Appellee Premium Title and Escrow. This case is about a business decision to entrust two individuals, Napoleon I.P. Zugbe and Kevin Faulkner, with the ability to make major decisions regarding 2 parcels of property. This business decision arguably resulted in a loss, and the appellants now seek to shift that loss to third parties. The ruling of the trial court granting Premium Title's motion for summary judgment should be affirmed because the court applied the plain language of the memorandum of understanding. The MOU in this case empowered I.B. Zugbe and Faulkner with the ability to make major decisions. There can be no claim for negligence against Premium Title because the Capital River parties' damages are caused by their own acts and omissions and not those of Premium Title. There are 3 principal reasons why the trial court should be affirmed. First, the Capital River parties unambiguously provided I.B. Zugbe and Faulkner with actual authority to enter into these transactions. 2, an allegedly forged operating agreement does not provide a basis to automatically void a deed of trust. And 3, no amount of discovery could rescue the Capital River parties' claims because they are attributable to the Capital River parties' own decisions. Simply put, the Superior Court did not ignore clear-cut law. The Superior Court did not authorize fraud, but the Superior Court undertook a thorough analysis of the governing documents the Capital River parties entered into voluntarily and correctly determined that I.B. Zugbe and Faulkner had the authority to enter into the transactions at issue.
So here's how I understand the negligence claim against Premium Title. Put aside whether or not Kevin and Napoleon could enter into the transaction. The escrow agent, Premium Title, is acting as an agent for Capital River LLC. And if they know somebody is trying to get a loan against the property through doctored documents, you owe a duty to inform the principal that, hey, even though these guys, even if you know that those guys, although based on the allegations you wouldn't, this seems to be a doctored operating agreement. We have the original operating agreement from 18 months ago in our files. And when you compare the two, they're different. Just thought you would want to know, Capital River LLC, so in case you have some recourse that you want to take. And it turns out that they might be able to show causation because it turns out that the Kevin and Napoleon agreed they didn't have the authority to do that under the MOU. Subsequently, they might be wrong about that, but they could have potentially been stopped. What's wrong with that as a theory of negligence? And how are we to say on this record, which doesn't exist, evident, I mean, it's a motion to dismiss stage, essentially. I know it's at summary judgment, but without discovery. How could we say what would have been the exercise of due diligence, what a responsible agent would have informed their principal of on this record?
Your Honor, I think it goes back to the duty of care. The appellants haven't identified a duty of care to look over prior records that have been closed. The complaint largely relies on the assumption that a volume business such as a title company would recall every prior transaction that it entered into, that an escrow agent would remember the source of the funds from a transaction.
I don't know about every, but a $1.6 million transaction that had taken place 18 months prior to the first loan, I believe is my memory, that has the exact same escrow agent on it. Maybe not, but maybe. Usually that's the type of thing you'd want some evidence on. Usually parties would present witnesses, experts to say what the standard of care is. And what they've alleged is you had that at your disposal. You could have just punched it into your database and it would have pulled up the prior operating agreement. You would have seen the discrepancy. For all I know, that is a breach of the duty of care, but usually I'd want some evidence on that we're missing.
Your Honor, I don't think evidence would rescue this particular claim, particularly because of the duty of care. There's no case that the appellants have pointed to that identified this duty to look over all prior closed files. I'm certainly sympathetic to that argument, but there's no controlling authority on that point and allowing.
But under our law, is it really about the authority, or is it the jury's province to look at the duty of care and the standard of care and determine that?
I don't think it's the jury's province in this instance, even assuming that there is a duty of care. The appellants pointed to the not assuming that there is a duty of care, assuming that the duty of care includes a duty to review prior closed files. The 15 standards of care that the appellants have cited to are secondary authority. They are treatises, they are non-binding cases. I don't think it's the province of the jury to determine if any of these, scattershot allegations demonstrate a breach.
I'd be really surprised if one could not come up with an expert who'd be willing to testify that it's the duty of, the duty of every title company to look back at its files when there is a transaction shortly after an initial transaction that would have given the title company a database of documents that it could use to check authority and other assorted things. I mean, experts testify about all kinds of things. I haven't seen a case either, but you really think that there's no expert out there who would come forth and give testimony of that sort?
Your Honor, that may be true. I don't think it would rescue this claim. I don't think the expert testimony could undermine the plain language of the memorandum of understanding. And I think the hurdle as to causation would remain.
Go ahead.
No, it's just, like I said, I don't understand why there is a hurdle as to causation. If we're talking about cause and fact, and you've got two gentlemen who are taking out this loan against the property who later admit they didn't have the authority to do it, even if they're wrong, if it was the obligation of the title company to inform Capital River, let's say Miss Lou, that this transaction was going down, well, then it seems like she has stated a plausible basis to think she could have stopped it. She could have told those two guys, you guys don't have authority to do this. And it seems like they would have agreed with her.
Your Honor, it's premium title's position that they did have authority to do it. And I don't think.
But what if they didn't know it?
I
mean, they later say, oh, we understand that we didn't have authority to do this under the MOU. Even if they're wrong about that, that would have given Miss Lou an ability to stop them from doing it based on telling them their shared understanding that they didn't have the authority to do it.
Your Honor, I don't think the subsequent hearsay allegations made regarding subsequent amendments to the complaint to the memorandum of understanding would undermine the plain language of the memorandum of understanding, which was the document in effect at the time. The District of Columbia courts apply the objective law of contracts. The ambiguity should not be imparted here where the language could not be more clear.
So you're telling me if you as premium title have somebody who comes out to take a loan, they have the authority to take the loan, and but you require them to provide 10 different documents. And you notice that all 10 of those documents are doctored and fraudulent. And they're trying to take out a loan on behalf of an LLC that has other members. You say you don't need to inform those other members. You don't need to inform the LLC of what appears to be a blatant fraud that you're presented with because they'd be allowed to do it anyway.
I don't think that's necessarily the position. I would think that based on the allegations and the complaint, there was no duty pled to look through prior filings. Besides innuendo that the same person handled both transactions, again, years apart.
I think what the allegations are that your escrow agent knew it was fraudulent and had an obligation to notify Capital River. Not that you had a duty to look back through the file. You already knew it. Now you might say, as a matter of fact, that's implausible. And that might be true. I just don't know how I would know that without any evidence. For all I know, every escrow agent in America is trained. The first thing you do is you go check this against any prior transactions that you've handled. That might be the evidence. But it's really odd to me to opine on that question without at a motion to dismiss stage.
Your Honor, I think it goes back to the duty of care, as Judge Thompson mentioned, as to the availability, the likelihood of an expert test being able to testify on this issue. Surely there would be some sort of primary authority on this set of facts regarding the obligation to look over prior closed filings. There is not. We're relying purely on secondary authority. There's no applicable standard of care regarding the ability to the requirement to look over prior closed files. And I don't think that any amount of discovery would reveal that.
All right,
Well,
counsel, sorry.
I'm just going to say that it seems to me that there are numerous cases where the facts of a case result in a ruling that the duty of care entails something that you don't yet see described in secondary authority. So I'm not sure. I mean, you are certainly right about the objective law of contracts and and I think Premium Title was entitled to rely on the authority granted to Napoleon and Kevin to make a transfer. But if the rest of the facts are, this is happening in a short amount of time after the initial transaction, and Premium Title knew that Ms. Liu had put up all the money and whatever else the complaint alleges that Premium Title might have known, it just seems to me there's enough there to get past the motion to dismiss stage and at least get to some inquiry into what duty, if any, Premium Title had to give notice to the entity, Capital River, or to Ms. Liu, or to check its database, or to do something that might have raised some red flags here.
Your Honor, that's a fair point. Again, this was at the summary judgment phase, and I think it relies on the assumption that the agent would have looked over the prior files. Surely the agent who closes on hundreds of transactions on any given stretch of time would not recall the specific source of funds for a transaction years beforehand. That's conjecture. And I don't think that would be enough.
And you're right, this was a summary judgment stage because Premium Title was dismissed upon summary judgment. Is that
That's
correct?
correct, Your Honor.
But summary judgment without discovery over the objection of Ms. Liu, who said we still need discovery on this before you address summary judgment.
I believe that allegation was made in the opposition. I don't recall there being an affidavit in support. I strike that, please. I don't want to represent that, but I remember that argument being made. But it's our position that no amount of discovery would cure the fact that the objective language of contract dictates that they, IP Zugbe and Faulkner had the authority to enter into this transaction.
Unless my colleagues have any further questions. Mr. West, we'll give you 2 minutes for rebuttal.
Thank you very much, Your Honor. This is the first time I've ever been in an appellate court where I had the most discovery delivered to me in the whole case rather than the trial before, where I just learned now that they in fact had an operating agreement where our client disappeared. She was not in it, as we surmised, but no one had ever seen that document, never gave it to us. They didn't give it to the court before. The court didn't know what the contents of that document was, apparently, because I couldn't present it and the other side didn't. And so how would you be able to reconcile what the differences of those documents were if you were the judge, if it's not presented to you? And the reason we weren't able to do it is because we didn't have any discovery in the case. And it's interesting, the argument back and forth about whether the end of the inquiry comes when you make the determination about the authority or not. is answered in part in the Smith case itself. It says this, even if the POA gave Mary Smith apparent authority to gift the property to herself, Wells Fargo may not rest on that apparent authority if it was on inquiry notice that Mary Smith did not actually have the authority the POA appeared to give her. And Wells Fargo was well aware of the circumstances which generated enough uncertainty about the state of that title that a person of ordinary prudence would inquire further about the circumstances. The reason I belabor the court's time with reading it is that in our case, we've pled a large number of facts which would have put the lender as well as Premium Title, both of the lenders, on inquiry notice about the facts surrounding Kevin and Napoleon. We pled in our complaint that Kevin had 39 complaints filed against him, many resulting in judgments based upon real estate fraud in the Washington, D.C. area.
Their principal response to this point is, okay, assume they were on inquiry notice. If they had inquired and looked deeper, they would have learned that Kevin and Napoleon had every right under the agreement to take out this transaction, to take out this loan against the property. So where does that get you?
Well,
there's no causation.
If I'm in inquiry notice, I now know I need to find out whether or not all the members are going to agree to the sale. And if I don't, I'm going to be sued. I mean, write it down. That will be what happened if you were to say, I made the loan with full knowledge of the fact that this woman was being cut out and defrauded. You will be sued. No reasonable lender would do so. No reasonable title insurance company would write the insurance policy in the case. And those are the reasons that it is manifestly unreasonable to take the position with that knowledge that this case can be decided at the motion to dismiss more than anything else. They knew or had reason to know. And the other interesting thing, and I don't know if I made the point clear enough, we don't know that any of the documents, besides what we heard here in our discovery exercise, were reviewed by anybody, because they certainly didn't have the MOU. That was not submitted to Premium Title ever. That would not have been in their file. The only thing they had in their file that we know of was the initial LLC operating agreement, which if they had looked and just type in the number, it would have popped up and shown it. And the funny side of the corollary of this about standard of care, it often is driven by economics. If you did not go look at your file as a title company and find that you had a recent transaction with a full title work and didn't do a bring down, you are arguably overcharging for your customers, because you wouldn't have had to order the full title search, and you could very well be thought to be engaging in practice which would likely violate most of the state's consumer protection acts. You would be very much in someone's eye line if you don't have to charge the full title search, but can just do a bring down, and you would look in your file just to know if it were there. And the difference is that you'll send a person out to do a full title bring down. It's a significant amount of work. It's a very large report. It charges a larger amount. A bring down is much less expensive. Everybody in the title business does it. Pipestone Title Company. This is what happens. That is what the standard of care is. And my opponent suggests that the standard of care is met in any way in this case, I suggest, is not reasonable, particularly in light of all the items that we put forth in the complaint. Where I don't think
did you plead enough in the complaint to keep BCJCL in this case?
I very much did, because I alleged as to the defendants, as to each of the allegations, that they were put on the same position. Right. In turn, it is set theory. I accuse all of the defendants of having either one, having this information, or two, being involved in the conspiracy that we have, or willfully disregarding this. Each of those counts is as to each of the defendants. So there are allegations sufficient to reach to them.
But some of the factual allegations don't apply to BCJCL, I take it.
Well, I think that's right.
At least I don't think you plead, perhaps I'm mistaken. You don't plead that they were involved in other transactions with Kevin and Napoleon, do you? I may be wrong.
I don't recall just at the moment, Judge, whether or not we allegedly been in another transaction with Napoleon. I don't want to guess. I do know that each of the allegations which we allege against all the defendants include them. They're all defendants. We didn't specify one of the lenders or the others. So the allegations they may need some more specificity, and that's when I would ask for leave to amend. But at the moment, we're in this case where my case is dismissed and without any recourse at all in rather remarkable fashion, because we don't know what documents anyone looked at. And this is the ultimate case where the MOU was found in a drawer somewhere. It wasn't one of the documents anyone looked at until the motions were filed in the court. We filed the initial LLC agreement, and then thereafter they obtained from us a copy of the MOU, which they then attached to the motions, and that's how they ended up prevailing. But no one ever looked at them. No one ever relied on them. None of the lenders can say, I read that document and that's why I made the loan.
Okay.
This is.
Okay, counsel. I think we have your argument. Try to give everybody a little additional time because it's a complex case, and we will take it under advisement.
Appreciate it very much. Thank you.
Next, we'll hear argument in 21 AA 821, Christopher Cummings versus DC Department of Motor Vehicles. It looks like we have counsel for Mr. Cummings
Yes, yes,
remotely.
yes.
All right, counsel, whenever you're ready.
Thank you. May it please the court, I'm Mr. Chesley Robinson. I'm counsel on behalf of Mr. Cummings. And this is regarding a disqualification of his commercial driver's license set back on March 27th, 2021. And so the letter from March 27th, 2021 disqualifies him for life for 3 violations, 2 of which, one from 2014, one from 2019, and a third from 2015. 2 of them were alleged to be driving under the influence. Third was alleged to be driving without a license. And so it's so that's what this appeal is about. It is our contention that the District of Columbia Department of Motor Vehicles illegally disqualified him for life by acting outside of the DC code. So I want to first start with the premise that, as we know, state agencies like the DMV are creatures of statute. So they are creatures of the statute that created them, which is the DC code. DC code provides for the disqualification of a commercial driver's license under limited circumstances. And those circumstances would include the circumstances under 1550 DC code 406A1, which would be the driving of a commercial vehicle while under the influence of alcohol. That it is clear that is not the case, and that is not even what is alleged in this matter.
Can I ask about that statute? 5406 does not on its face appear to say when DMV can or may disqualify somebody from a commercial driver's license. It says only when it shall, when it must,
right,
without purporting to be an exhaustive list of when it otherwise may. So one argument, although I'm not sure the district is making it here, one argument they might make is, 5406 is just a requirement of when we need to revoke commercial driver's licenses, but it doesn't restrict us from passing regulations that otherwise permit us to revoke those commercial driver's licenses. What is your reaction to that line of thought?
Well, I would say this, that what would be required, although there's no provision that is restricting the suspension or disqualification under, a million different items, there should be, the code is the universe upon which the DMV can operate. And so the problem with that analysis is that the DMV could theoretically suspend for any number of things in which a person would have no notice of. They could create regulations that expand their authority, which the DC code has not provided them. So the DC code does say when they shall suspend, but it doesn't give any indication of when they may suspend or other instances that would be appropriate to suspend. So because of that, the only authority that is granted under the code is those instances where they shall, where they must. That does not give them any other authority. To read into the regulations additional authority that is not granted by the DC code would allow the agency to essentially make law, to essentially circumvent the city council and to essentially become the executive itself.
But council, the agency is not doing this independently, are they? Isn't this part of the set of regulations that, like many other areas of the DC regulations, city council has to accept by passing a resolution and review?
Well, it is true that there is a process upon which the regulations are approved. However, the process is not as arduous as the process for creating law. And DC law has been very clear that when there is inconsistency between a regulation and between the code trumps the regulation. And so under these circumstances, it would be inappropriate for a regulation to be created, which is a process that is driven by the agency and presented to the city council, versus city council actually making law. It would be inappropriate to take a regulation that expands the authority of the city council, of an agency, take that regulation and then apply it over top of the authority that's provided by the code. It has to work the other way. Otherwise, an agency could essentially just create endless regulations and engage in behavior that is either not authorized or is inappropriate under the code.
Isn't that what happens in a number of schemes, particularly where there's some federal regulation like there is in this case, and then the opportunity for local regulation, like take, for instance, the occupational safety and health setup. The federal government passes a baseline level of regulations, and states or in other jurisdictions like DC are free to pass their own regulations, but those regulations can't ease the requirements beyond what the federal government allows. They have to restrict them further.
Well, in regulations such as the ones that you're describing, you could say the same about the regulations under disabilities laws like the IDEA or 504 as such, specifically spell out the floor. But the law under the US code and those regulations don't spell out the floor for a state. What it specifically does is say that the secretary shall enforce these. And if the state does not, then the secretary shall or the secretary may. That's the language within the US code. So if you look at 49 USC section 31.310 H, it specifically states that if the state does not disqualify for XYZ, then the secretary shall. So under that scheme of federal regulation, then it would not be for the state it would not circumvent the state's policy, but it would be that the secretary could step in and take action, and which is noteworthy because the secretary did not step in and take action either in 2014 or in 2019. Now, there are other reasons that I believe for that to be the case, which are important to this case. But in this instance, because the scheme is set up so the secretary can step in and take action, then it would not be for the state to then expand its authority under federal regulation or under its own regulation. Still is limited by what is within the code.
Well, I think the case law that you rely on, Mr. Robinson, that venerable case law, which says that a regulation that exceeds what the statute provides as a nullity, that case law doesn't take into account the situation with respect to the DC Council's adoption sometimes or approval of regulations. I don't know that there is any other legislature in the country, there might be, but I'm not aware of it, any other legislature which sometimes does its work through statutory amendments, but sometimes enacts regulations, adds material to the DCMR, which has the force of law. The DC Council did that, for example, with respect to the disclosure of body-worn camera video that police officers wear. It put out a set of regulations in the DCMR addressing disclosure of that. And the DC Code, in fact, the Home Rule Act even says that the council may make police regulations for the protection of life and limb. And our court has recognized that the council has on numerous occasions enacted legislation by putting provisions into the DCMR. So when the council does what it did here, which is to say it adopted a resolution and essentially said, we approve those regulations that DMV promulgated, why is that not enough to overcome the problem that you say is created by that case law? Because the case law about regs being a nullity if they conflict with the statute, those cases do not appear to contemplate the situation we have here, where the council actually adopts or approves regulations. What's your answer to that?
Well, I think that where it expands the authority of the agency, I think is a unique situation versus where it is just spelling out how we're going to implement the law, or where there is something that is addressed in the code versus something that is not. Here, the code addresses what is to be done in a particular situation. This is expanding the authority of the DMV to suspend someone's license, which is their livelihood, for life. And so I think that the distinction in this situation between, say, the regulations that you're discussing regarding the body cameras is that one is not expanding the authority of the agency to act, where this one would clearly be expanding the agency's authority to act. And the city council would have time. Would have time to change the law if that was their intent. But here, they never did that. They never actually changed the law.
But the Home Rule Act empowers the council to act in a number of ways. It can amend the statute. It can issue police regulations. It can legislate through regulations, so to speak. And that appears to be what it did. There doesn't seem to be any practical difference between what happened here, the council adopting a resolution approving the DMV regulations, which brought the district law into conformity with the federal highway law, and the council actually looking at the regulations that have been promulgated and re-promulgating them itself, which would seem to be sort of a useless act with the regulations already out there. Why should we hold the district to something which would be essentially useless when the council has effectively acted through the resolution?
Well, because what is created under this situation, again, you have two things that are inconsistent. So you have one that is giving a greater amount of authority to the DMV and one that's giving a set amount of authority to the DMV. So as a citizen, I have two sets of laws. And I have to determine between myself which one applies.
But what you know as a citizen is that you're on constructive notice of what the council published in the DC Register, which is approval of these regulations.
Well, that may be the case. I mean, that is the case, but it's also the case that there is a DC code that exists, and the DC code does provide for a specific scheme. And so when there is created multiple different schemes, it is clearly confusing to the public, which is the reason why there should not be an inconsistency between the two. So
Council, can I just repeat? This kind of comes back to my initial question of whether or not there is an inconsistency. I think I would agree with you if what 5406 said was the mayor may only disqualify for the following reasons. But when it says these are reasons that the mayor shall disqualify people, it seems to leave some room for, and there is some discretion to disqualify them in other ways. And I might, I'm not sure, 5402 seems to deal with initial licensing. But 5402 does say at the beginning that the mayor shall adopt and administer a program to test and ensure the fitness of a person to operate a commercial motor vehicle. That seems to be a pretty sweeping grant of authority for the mayor to create a licensure scheme. And I grant you, it can't conflict with the statute. But I'm just curious as to why you think it does if the mayor adds additional bases to disqualify people that are not statutorily required. So they're outside of 5406, but might be regulatorily required. I don't know why that conflicts with the statute.
Well, I believe it conflicts with the statute because the statute which contemplated additional situations did not allow for that. It didn't give, in other words, it doesn't necessarily limit, but at the same time, it does not allow for additional reasoning. It is very clear. It gives a very set out standard, and it's very specific in the entirety of the section. So it appears to be comprehensive, and it appears to take into account what it could have done and could not have done, and decided to go upon this. And so when you create a regulation that then expands upon that, I think that's what creates the confusion, and that's what gives the agency more authority than they would be granted under the code, in which the code is that upon which the DMV was created.
And so what's your reaction to the language in 5402 that the mayor is authorized to adopt and administer a program to ensure the fitness of a person to drive a commercial motor vehicle? Is that not some grant of authority beyond 5406? Your answer might be that only applies to an initial licensure scheme, which is sort of how 5402 reads. But I'm just curious what your reaction to it is.
Well, that's exactly where I was going to go, and that goes to my additional point. And I haven't gotten into the issue with records in this matter, but that does go to the initial point that this was an action that was taken after the fact. And this was an action that was taken after the fact of an incident, not in the immediate instance, but this was after the fact. So what happens is these instances that they're using occurred. He moves to DC. He is then granted a commercial driver's license. So DC had the ability to consider this information and to then take action by withholding that. But that is not what they did. They granted a CDL, and then they went backwards in time and plucked things out from 5 or 6 years prior and accumulated them together to come up with a lifetime ban. Well, which at this point is a 10-year ban because they've conceded that the 2015 incident was not a major traffic violation. So it would be 2, and it would be a lifetime, which with the opportunity of reinstatement after 10 years, based on the concessions of the appellee. But the fact here is that that would apply to the initial judgment, and at the time that the petitioner.
Well, counsel, let me ask you, because I'm a little bit confused then. My understanding was that what happened was your client transferred his license over. He didn't apply for a new one.
That's correct.
And was his license was his CDL in good standing when he transferred it over?
It was absolutely in good standing when he.
So then why would DC have needed to go and look further in if Maryland said this license was in good standing at the time? Why should they have reasonably discovered or been on notice of the previous violations?
Well, the one reason they should have been on notice is I'm going to go back and to go to the federal statute, because this is the part where I believe it applies when the transfer. And so if you look at the federal regulation, 49 CFR section 384-107, that incorporates by reference the manuals, which talk about the transfer of records. And we get into this in the brief where we talk about how the DC Court of Appeals has interpreted what a record is. But in this instance, the and I want to get the language, I don't want to be specific, but in this instance, the issue that comes up is that the state of conviction is to send the official record to the state of record immediately. So at the point of transfer, there's supposed to be a transfer of information at that point. And then at that point, there's supposed to be action that is to be taken, if there's going to be action to be taken. That is what is in the federal regulations. That is what is promulgated by the federal law.
Okay, well, let me ask you then, and I may take you slightly off topic here, but if you feel we should rely on the federal regulations there, why does this not all then fall apart with us relying on a federal regulation saying that it doesn't matter if it's a commercial license or a personal license that the inebriated driving occurred under?
Well, the only reason that I bring up the federal regulations at this point is because this is specifically when he is transferring from one state to another state. And so we were just talking about the transfer of records, but which is a different situation from when the state is going to specifically take state action. This is just about the transfer of records. Now, to be very candid, I don't believe that, I believe that you would still be looking at what is required as far as transferring records under the DC code. And it is my position that the transfer of records still has to be a transfer of an official or certified record. That standard that was recognized in Osborne. And I understand that was a different type of DMV case, but it still sets the standard that these are the type of records that are supposed to be transferred. In petitioner situation, you have an instance from 2014 in which the petitioner has first of all, not conceded to pleading guilty to driving under the influence. The only thing he has conceded to is that there was a probation before judgment agreement. However, that's been dismissed, and under Maryland law, and remember, he was a Maryland driver. He was a Maryland driver with a Maryland license at the time of that incident. Under Maryland law, which would be 6 Maryland Code 2020 G3, upon the conclusion of something under a probation before judgment, it is not a conviction to be used for the disqualification of a license. So that would be the first instance. And if that doesn't exist, then you would only, this is whether you apply the regulations or whether you apply the federal statute or not, you would only be looking at the instance from 2019.
You didn't make that argument before DMV, or Mr. Cummings did not. Is that correct?
That
Is
is
it correct that he did not present that argument to the DMV?
It is correct that in the initial instance, in the initial appeal, that the argument that was made was the argument regarding that under the DC code, that the regulation under the DC code that they can only suspend him for an instance of him being within his commercial vehicle. And so there was not an argument that the 2014 case was a legal nullity. That was not part of the initial appeal.
You know, you spent some time talking about the federal statute and the enforcement authority of the secretary, but since you more recently referred to the federal regulations, 49 CFR Part 383 says that it applies to any person who operates a commercial motor vehicle, and Part 383, I forget which part it is, I guess it's 51, actually describes the periods of disqualification. Essentially, it says anybody who has these types of offenses is disqualified from having a commercial driver's license. And it doesn't say anything about who enforces. It is a direct disqualification. It seems to me that to grant the relief you want here, which is a reversal of DMV's decision, would bring us squarely in conflict with that federal regulation. What's your response to that?
Well, again, I believe that the federal regulation also accounts for that the federal statute being enforced by Secretary of Transportation. And it specifically states that where the state does not take a particular action, that's where the Secretary of State can.
And
So-
the secretary might do a number of things, reduce federal highway funding, decertify DMV's ability to issue commercial driver's licenses. It has a number of ways to enforce. But its direct language is that any person who has these infractions, including driving under the influence, is disqualified. So the relief that you want would bring us squarely in conflict with that federal regulation.
Well, again, it's my position, and I believe this is the case, that the state can implement the DC code. And it would be for the secretary to step in to say that if he was to say that the federal law preempts the state law. It would not be for the state to say that the federal law preempts our own statute, which regulates our activity. Because again, they are a creature of state statute. And so it's my client's position, it's my position that the DC code governs the actions of the DMV. And so the DMV would have to take actions consistent with the DC code. And if there was a further action to be taken, that action could be taken by the secretary. But the DMV is governed by the DC code. But I do want to go back to the fact that, I mean, we do have an administrative record, and the administrative record does not have any record of the instances that occurred, that they're saying occurred, or any records from Maryland, or any official or certified records from Maryland. So if they're going to rely on the federal statute, I think they also have to rely on their obligation to obtain appropriate records, upon which, if there's an allegation made, Mr. Cummings would have an opportunity to respond.
Counsel, what does your client really get from that, though? It's kind of a so what question. Does your client deny that those records actually exist?
Well, two things. Number one, my client would the record from 2014 at this point does not exist because it's dismissed, it's a nullity.
But the federal regulation specifically directs states to disregard those kind of expungement provisions in applying the disqualification regulations.
But the second thing is, again, my client took the position in his appeal below. My client took the position that the DMV is obligated under the DC code to act consistent with the DC code. But there was never an admission, and my client has never made any statement saying that he pled guilty to this action. The only thing that he said is that he took a probation before judgment, but there's never been a proffer of facts as to this is what he is admitting to and agreeing to, and he has no recollection of ever admitting or agreeing to any of those things. He, took an action on the advice of counsel for a number of reasons, and move forward with that. It is also important to note that there was not a prior action taken on a CDL at that point either.
Okay, counsel. Unless we've taken you well over your time, unless my colleagues have further questions, we will hear from counsel for the District of Columbia. Ms. Anderson.
Good morning, Your Honor. Stacey Anderson on behalf of the Department of Motor Vehicles. Your Honors, before we get to the heart of the case, I did want to acknowledge that we are asking for a remand in this case so that the director can lift that unconditional lifetime disqualification. But as for the primary issue here, whether or not the regulations amending the list of disqualifying convictions was proper. It's the district's position that it was well within the DMV's authority here to do so. We look at the statute. The statute, as Judge Jill pointed out, is not one in which it has said that the only disqualifying conditions are the ones listed in the statute. And that's why we believe there's no conflict here. What DMV simply did with the council's affirmative approval was to expand the list in keeping with the council's intent all along, which was to ensure that the district was in compliance with federal law to secure our apportionment of federal highway funding. So consistent with that, the DMV, when Congress amended the Safety Act in 1999, promulgated these regulations, and they were again affirmatively approved by the council, reflecting the council's view not only that this was in keeping with its original intent, but also its view that it had conferred rulemaking authority upon the DMV to do so.
Counsel, let me ask you, and this may not be as big of a deal, but it was something that was sticking with me, so I just wanted you to address it. So the original act came about with a federal act as well, and a statute was passed. We could take the reading of the statute that you proposed and that Judge Deal questioned, but if we took your opponent's reading of it and that granted these regulations were passed and approved by the city council, congressional review that would normally happen under a statute is missing. Does that change things? And how would you address that?
Yeah, Your Honor, I guess the question I think turns on again, what was the scope of the DMV's rulemaking authority here, or the council's rulemaking authority? And I don't think that the congressional review was required here. Judge Deal, you pointed to 5402. I would point also to 5402 subsection 8. That is a little bit of help here because it cross-references the old statutory list of what the district needed to do to stay in conformity. But that at least anticipated that there may be rulemaking authority beyond what was expressly set out in the statute. And I think that's some indication, again, going back to the council's intent here all along. And I think Congress Congress's intent as well here that we comply with federal law to ensure safety on our highways and a uniform system of licensing and disciplining commercial driver's licenses. So it's our view that the scope of the rulemaking authority here was broad enough to confer this authority on DMV. And we believe the council confirmed that understanding when it affirmatively approved the district's regulations.
You, in your brief, seem not to embrace the rationale that the DMV director first articulated in announcing the disqualification, which I believe was an explanation about the supremacy of federal law. Instead, you talk about comity and you talk about frustrating the purposes of Congress. Why do you not think that the federal regulations apply in a way that implicates the supremacy clause?
Right. Well, Your Honor, this is spending clause legislation. And this is spending clause legislation. So generally, that gives the district the option not to participate in the program. So here, Congress has imposed some consequences we've talked about this morning, the loss of a portion of our federal highway funding, also the ability to certify or issue commercial driver's license. That authority can be decertified. So the district could opt out of this program entirely. And Congress is not mandating that we participate. It's giving us carrots to do so. So in those instances, courts generally recognize that that type of legislation is not preemptive in effect because it does not mandate that the state do anything in particular.
There are a number of spending clause provisions, though. I guess I'm most familiar with the Medicaid statute, which contains lots of provisions about what state Medicaid agencies must do. Even though, as with federal highway funding, the condition of violating federal law is that you lose your Medicaid funding. It's a joint federal state program. So if you don't run your program in the way Congress says, you lose the money. Nevertheless, the courts have found, for example, that the statute creates enforceable private rights of action for individuals. And so Medicaid agencies have to pay healthcare providers a certain amount of money, and they have to guarantee free choice of providers for Medicaid beneficiaries, et cetera, even though it is a contractual thing, do this or lose your money. I don't know why the same thing wouldn't apply in this context.
I think again, the structure is different because here we have kind of the federal government will take action if the state doesn't. In other words, the secretary here is charged with, if the state doesn't disqualify, the secretary will. So we really have a dual system.
We do,
place.
although the federal regulation is couched in the language of this Part 383 applies to everybody who drives a commercial vehicle. You are disqualified if, and it doesn't sound like dual enforcement. It sounds like a direct federal requirement.
Right. Well, so that I think that regulation was a result of 49 USC 310G, which was the directive to the secretary to promulgate a regulation that required disqualification. So I think that's a byproduct of that. I think there's still, the Congress had contemplated that there would be someone taking action, whether it be the secretary himself or the state. So I think the statutory schemes are slightly different, and that accounts for, I think, our view that this really is truly a spending clause legislation, and we can't opt out. If we accept the funding, of course, we are obligated to comply with the conditions of that. But to the extent that we are not going to participate, there is there's no obligation to disqualify commercial driver's licenses. That's our view.
As a statutory matter, going back to 5402, what's your reaction to Mr. Robinson's point that 5402 looks like it authorizes the mayor to pass robust regulations about an initial licensure scheme? You know, if you look down through the numerals, it's the mayor shall issue, not issue or renew, not issue, not issue. It seems to be talking about, you know, what you can do in making the initial determination or renewal determination about a license. But there's nothing quite like that with regard to disqualifying a somebody's commercial driver's license, in which all you've got is 5406, which has this mandatory language. Do you think we can read, and maybe you have an option C. You can read 5402 as also extending to disqualification determinations. B, there's just a gray space, so the statute doesn't speak to about discretionary disqualification decisions. Or C, you know, if you have a different answer, I'd love to hear it.
Right. So I think you can read it to apply, because again, take a hypothetical where Mr. Cummings didn't have a commercial driver's license, and he came to the district with these two convictions and wanted a driver's license. I think our answer would be no, you may not have a commercial driver's license. You're disqualified. So I don't know that that's any different than having issued it and he becomes disqualified. Why we couldn't, in those same circumstances, say, okay, now we're taking your license back because you no longer meet these minimum requirements for licensure. So if you look at it as what are the requirements for licensure, you satisfy them or you don't, we have rulemaking authority for making that determination. I would also again point to 5409, which is the rulemaking authority, the express grant of rulemaking authority, and it is to implement the provisions of the chapter, which would again include 5406. And then I would also go back to what I mentioned earlier, 402(8), where it is, but for the cross-reference to the statute that no longer exists. If that were a cross-reference to today's statute, beyond a doubt, it would be clear that the council intended for the mayor to take other steps to ensure whatever we needed to ensure to maintain our federal highway funding and be in compliance with those requirements.
I take it that I can't recall off the top of my head, but that the Commercial Motor Vehicle Safety Act also had requirements for, required disqualifications, if this were
Right.
Including the one that is in our statute about if these infractions had occurred while he was driving a commercial vehicle. So that's one reason that you could kind of expand 5402 to apply to disqualification determinations. Is that part of the thinking?
Yeah, I mean, that's part of the thinking. Yes. Again, our statute was intended to reflect identically what the federal requirements were at the time it was passed. And again, we've got this amendment, which is added additional requirements, and council, instead of amending the statute, went the rulemaking route and approved DMV's regulations. But functionally, there's no real dispute that would have been proper had it been an amendment. Again, we're just simply mirroring what the feds have enacted most recently. And I think we've achieved that. And looking at the legislative history in particular, it is clear that that's all council had ever intended here, was just to maintain our compliance with federal law to ensure that funding. And that's what our current regulations reflect today. There's no conflict. What's in our statute still applies. The regulations have not nullified that in any way. And those are continued to be requirements. For example, commercial drivers who have a blood alcohol content of 0.04 are subject to disqualification if they're operating a commercial vehicle. That holds true today. It's in the original statute. We haven't altered that in any way. We've simply expanded the list to match the federal requirements.
I don't know whether Mr. Robinson made any additional points in his argument about the records that DMV relied on, but I wanted to give you an opportunity to respond if you thought he did. I think you did address the argument in his brief.
Yeah, we did, Your Honor. I think the records are entirely proper. Again, I wish he had raised this before the director, so that we could have gone through and explained how we use the commercial driver's license information system and the automated automobile administrators network to gather information from other states. Our courts report to DMV when there's a conviction. DMV in turn uploads that information into these national databases so that other states have the opportunity to see these driving records, particularly for commercial drivers, and we'll know whether or not when they're issuing licenses, the drivers are qualified or disqualified from operating commercial vehicles. And so we believe that what we've done here is entirely proper. It's consistent with our regulatory scheme. It's consistent with how our database operates. What the director relied on was Mr. Cummings' driving record, which reflects his convictions in Maryland. As all district residents, convictions from anywhere in the country, if you get convicted out of state, it's going to end up on your DMV record because that gets again reported to those national databases. Here, Mr. Cummings did not dispute those convictions. And on the question of whether or not the probation before judgment is a valid conviction, Judge Thompson, as you pointed out, the federal regulations count that, and as do our DCMR regulations. The definition of conviction in 18 DCMR 1399 would also include that, notwithstanding the fact that it was probation before judgment in Maryland. But again, that wasn't an issue raised below, or I don't believe in Mr. Cummings' opening brief. But there's just simply no basis to dispute on this record that Mr. Cummings has the two convictions, and he had an opportunity to do so and did not. So it's simply the legal question of whether or not that those are valid basis for disqualification, and it's our view that they are. And for that reason, we would ask the court to affirm the lifetime disqualification subject to a 10-year reinstatement, or the possibility of reinstatement in 10 years.
10 years starting from when?
It would have been from the date of the disqualification. So we're not quibbling with, from the date of this court's decision. We will go back to April 10th of 2021 and start the clock then. Thank you, Your Honors.
All right, Mr. Robinson, we will give you a few minutes for rebuttal. Mr. Robinson, you're still on mute.
I apologize.
Happens all the time.
I do want to point out, counsel for the respondent did indicated that petitioner had an opportunity to raise the issue of the record, but that's not the case. In fact, as was pointed out in our brief and in our opposition to their summary affirmance, the record that was available to Mr. Cummings did not have these things on it. In fact, the things that we're talking about were only available to the petitioner after the administrative record was filed. They had no idea what was on that record until that point. So the idea that
So counsel, is there anything he can dispute now though? Like where is the harm and the error if there ever exists?
Well, the main point is that the petitioner did not have an opportunity to address the 2014, and in fact there are still no records for that on the record that's up on appeal, on the administrative record. Just a notation in the DC record, but there's no actual information from Maryland or no information that it was obtained from Maryland, which are things that should be in the administrative record, by the way. There should be at least a date stamp or a certified copy from the time the decision was made, that those records were available at the time, but there's not. And there was no opportunity for my client to either explain or express the facts behind that instance.
So does your client have anything to explain or express on that beyond the expungement point?
The only issue that my client raises is the fact that he did not, and I believe the definition that counsel raised requires a plea of guilty, and that he is indicating that there was not a plea of guilty to driving under the influence, that he essentially took a probation before judgment, but it did not include a plea of saying that he was guilty of that event. So my client has concerns that had he had the opportunity to address this record, that he would have been able to do that. Again, in his initial reply, the instance was that this is something that DMV cannot do. And we still agree with that point, that the DMV should be limited to what is in the DC code. It should not be expanded. We do not agree with the position that under 402 that it will be expanded, or that new regulations can expand their authority. But even under that, there was no opportunity to be able to address those allegations. There was no opportunity to be able to address the facts behind it, which also becomes important because there's nothing in the record to indicate that that there was ever any adverse action on the CDL in Maryland, which is important to note. That's not in the record. It's not on his DC record that's in the administrative record. It's important to note that because it shows that it would have been important for my client's due process to have had an opportunity to address these allegations, but instead it was simply a letter saying that you were disqualified for life.
All right, counsel, we have your argument. We will take the case under advisement and we appreciate everybody's arguments.
Thank you.
The panel now needs to take just a 5-minute recess to reconstitute before the third argument of the morning. So we will take a brief recess and be back out shortly.
All right. Court is now in session. You may be seated.
Okay, good morning again, everybody. With the panel reconstituted, we will hear argument in our third case today, which is 22 CV 303, Keisha Staley versus the District of Columbia. Counsel for Ms. Staley, when you stand, can you let us know how you'll be dividing the argument with amicus? Whoever's going first can let me know that.
Yes, thank you, Your Honor. Seth Jaffe, appearing on behalf of the amicus Empower DC. Mr. Barnes and I will be sharing our time equally. I understood that we get a bonus minute, 8 and 8.
Is that how it works? Okay, good enough. Good enough for me.
That's what I was told.
I'm gonna give the district an extra minute though.
Life is unfair sometimes. I'll be speaking today to the District of Columbia Environmental Policy Act aspects of the case. This is an important case and it has ramifications just beyond just the bus depot at issue here. That broader significance is part of why Empower DC asked us to file an amicus brief, and it's why we sought oral argument. Because the case is about whether the DC Environmental Policy Act allows project proponents to violate the explicit provisions of the act and then actually use those violations as the reason why the plaintiffs don't have standing, because the information that would normally come to light as a result of EPA compliance, isn't there. Because that cannot be the law and is not the law. the decision below should be reversed. And the case should be remanded to the trial court with instructions to direct the district to prepare a full, environmental impact statement. So the basic requirements of standing are pretty clear and undisputed. First, an injury that is concrete, particularized, actual, or imminent must be present. And that injury must be B, fairly traceable to the defendant's conduct, and C, likely to be addressed by a favorable ruling. And what happened here is that the Superior Court below erred in looking whether the plaintiff had provided sufficient evidence of a substantive environmental harm, rather than looking at the procedural harm caused by the district's failure to comply with EPA. And that is directly contradicted by this court's decision in Friends of Tilden Park versus DC. And that's language is important enough. I'm going to quote briefly. The procedural injury implicit in agency failure to prepare an EIS, the creation of a risk that serious environmental impacts will be overlooked, is itself sufficient injury in fact to support standing, provided this injury is alleged by a plaintiff having sufficient geographical nexus to the site of the challenge project to expect to suffer whatever injury the project may cause. So they don't have to demonstrate the substantive injury. They just have to be in a position where if there is some substantive injury, they will be affected.
Was this argument made to the trial court? My impression is that this is something you're raising for the first time on appeal.
So, Your Honor, it certainly was not made as clearly as it might have been. And I totally understand why the Superior Court might have gone wrong. That is why Empower DC sought leave to file an amicus brief here, is to make certain that the court was fully aware of binding precedent in this case.
Doesn't the argument also presuppose that the EIS is a requirement? Like we'd have to find that first before we could even get to that point. Right?
So if I might, Your Honor, there are steps in the EPA process, and I'll go through there. I think they lead pretty clearly to unavoidable conclusion that an EIS is required. But at least even the initial steps of EPA compliance, in this case, it's an environmental impact.
The EISF.
Yes, the EISF is required.
So it's your position that no direct harm need be shown by the plaintiff.
No,
it's enough simply to say there was a procedural error. I'm a human being. I live in the environment. Therefore, I have standing.
No, it has to be more than that. But part of it is there's a temporal approach to this. So at the time where you're addressing standing in connection with an original complaint, you do not need to demonstrate substantive harm. You need to demonstrate the procedural violation, and you have to demonstrate that you live close enough to the project site that if there is harm, you will suffer it.
Well,
but
that's
what this
something
court
more.
said in Friends of Tilden Park. I was just quoting.
So as a matter of law, 1/3 of a mile is close enough.
So I think that's a continuum, Your Honor, and you can imagine some cases where the distance that's sufficient to demonstrate a geographical nexus might vary. So in many of the federal cases, plaintiffs have been found to have standing where they're 20, 30, 40 miles away. And that's because there are air emissions that could migrate or water going downstream. Here, the plaintiffs did allege in their complaint that there are air issues, there are noise issues, there are traffic issues. We don't know how severe those are, but under Tilden Park, those are the types of injuries that if they do happen, and they may happen,
Well,
if the district violates, I'm sorry, go ahead.
No, in Tilden Park, the harm was already established. And even the government had found that there was harm, which is why they required the developer to go back and do some more work and come up with a mitigation plan. Here, the very things that are being complained about are things that the government's already looked at, right? And so the question of harm is somewhat open here, and I'm assuming it's your co-counsel here that's going to address some of those and whether that harm actually formally exists and the sufficiency of the government's efforts to look at it.
So I can address those as well. I can address all of the Environmental Policy Act issues. And the answer is, and I say this somewhat rhetorically, but the government can't cheat. It can't violate the procedural requirements of the EPA and then do something post hoc, ad hoc, outside the bounds of what the procedures are under the EPA and say, we've demonstrated no harm, we're good. Because part of those procedural requirements in the EPA are designed to protect public involvement. And we didn't have the opportunities for public involvement. Our clients didn't, the plaintiffs didn't have the opportunities for public involvement that they would have had if the district had done what they've said they've done in ways that aren't even part of the joint appendix in the record. But we didn't have a chance to review those. And that's precisely why the procedural violation is enough to establish standing. Because if you put the substantive harm first, you turn the statute on its head. And the plaintiffs don't have the opportunity, they get dismissed out before they even have the right to have that study done where they can participate in it, they can have public comment.
Was the procedural, what precisely was the procedural error that was made? Is it the failure to, was it the failure to prepare an EISF?
There are two requirements. One related to the timing of the EISF and the other relates to whether an environmental impact statement is required. So I'll go over those if I might briefly. So the first procedural injury that the plaintiff suffered is that the district didn't prepare the EISF until almost 2 years after they started construction on the project. So if you look at the record at page 100, you see that construction started in April 2020. The environmental impact screening form wasn't done until February of 2022. And the district code of regulations provides explicitly that any project that's going to cost more than $1 million, that's not an issue here. It's acknowledged here. And that may have a significant impact on the environment, requires an environmental impact screening form. So they had to do the form. All of these cases, there's sort of a no harm, no foul approach that the district is taking here.
In something that's not in the record, which is true for many things that are in the briefs, but in this particular case, I thought the district in its brief says, but we did prepare one eventually.
Yes, again.
After the trial court made its ruling, to be sure.
Correct. And that was what I was just acknowledging. So even after, yes, as you say, after construction started, after the trial court ruled, they prepared the EISF. But the cases are clear that while you can cure these types of procedural failures, you're supposed to cure before you start construction. Otherwise,
I know, but in real life, what's the point?
Well,
they didn't do it, but they eventually did it. And
well, let me get to the second violation, and then we'll get to whether there is anything left to do. And we think that the answer is there is work left to do. So the first violation is the failure to do the EISF timely. And I just want to note that may have language in the regulations that require the submittal of the EISF mirrors the language in Tilden Park, that if there may be harm, the plaintiffs have standing. The other procedural violation is the failure to either prepare an environmental impact statement or submit to public comments, submit to the city council a statement why an EIS is not required. And that is very clear in the district code. Section 8-10903 says if the mayor, board, commission, whatever, determines that an EIS is not necessary, they shall prepare this explanation and submit it to the city council and submit it for public comment. And
was the failure to do that raised before the trial court?
I don't know, Your Honor. I'd have to check.
I mean, I guess the flavor of the argument is, okay, if, let's say they should have, but failed to in a timely way, prepare an EISF. Normally, if that's raised, and you're right, the remedy would be, okay, district, go prepare an EISF. That's already done. It seems like that type of argument, if it were a standalone argument, would be moot. That they've already done, there's no redressability. They've already done the thing that you're asking them to do. And then
I'll hold it, but I'm going to take issue with that, Your Honor.
oh, sure. No, please go ahead now.
Okay, just, it goes back to this notion that they can do everything on their own and not submit it to public comment. You still are avoiding the review that you normally get under the Environmental Policy Act. So I think that the EISF, partly because they'd gone so far already, what became moot, but moot in a way that is so contrary to the Environmental Policy Act that it can't be honored, because the plaintiffs didn't have a chance to challenge what was in the EISF. And that's the point of making procedural harms actionable under the EPA.
Well, help me to clarify this in the record, because this goes back to my original presupposing point for your argument. What I imagine the district is going to argue, but I didn't get necessarily directly from the brief. It looks to me like there is a plausible theory out there the district may have that, you know, both 8109.03A and elsewhere with the EISF, this all requires not only a major action, but it's likely to have a substantial negative impact on the environment. I imagine the district's point is we took a look at the things we believed would have a negative impact, and we determined we didn't need this. And it's not that we did this later because we knew we needed to do it originally, but it was when we discovered the potential petroleum contamination and the tanks underground. And then we took the procedural steps at the right time when we knew there was a potential for a substantial negative impact. How do you address that one, or how do you thwart that in the narrative of things? Because I'm not sure it's completely clear to me from the record.
Fair enough, Your Honor. That's why we're here. There are differing provisions in both the code and the regulations. And I'm an environmental lawyer, so I'm used to this. These statutes aren't always as clear as either judges or practitioners might like. But I think that section 810903 C2, which is the language about requiring an environmental impact statement to deal with projects that will involve a bunch of things, but among them, the disposal of hazardous substances, is not, as the district argued in its brief, conditioned upon there being some kind of violation. That's a freestanding obligation. Any project that is subject to the EISF, basically, that in other words, is more than $1 million and that may have an impact, doesn't have to, that we know has an impact, but just more than $1 million may have an impact. You're doing an EISF. If either in the context of doing that, or you already know for some other reason, the project is going to involve the disposal of hazardous substances, without regard to whether that's a violation, and I can actually explain why it is a violation also, but without regard to whether there's a violation, they either have to do an EIS or they have to explain why they're not. It's not conditioned upon anything. It's independent of the other provisions that may be ambiguous, but you can't use those other ambiguous provisions to overrule the clear language in 88-10903 or in the code 20-72053. It's just, it's as clear as could be. If I might just very quickly talk about why there's actually is a violation of law as well, partly because that goes to what may still be out there because we don't know, I'm repeating myself, but because they haven't complied, we don't know everything. But those tanks that, and I'm going to freely confess so you can stop me, this is an argument that was not made previously, but I think all of it is information that you could take judicial notice of. The District of Columbia Code of Regulations 20-6100 and 6101 make clear that if there are underground storage tanks that have been basically unused, they become abandoned. After 12 months, if they're unused, they have to be removed. It is clear from the joint appendix that that there are underground storage tanks at that site that were there for more than a year without having been closed as required. Not only that, but in fact, the site is on the DC list of sites that have leaking underground storage tanks. There actually is real, while I'm standing firm on the notion we don't have to demonstrate substantive environmental harm at this stage, there's a real risk of substantive environmental harm in connection with these. And I acknowledge that part of the project is to remove those tanks and fix that. But again, it's got to be subject to the procedures of the EPA so that the public has a chance to participate and raise any concerns.
Well,
But
assuming that something more has to be shown, are you or Mr. Barnes going to talk about why there is in fact concrete injury to your plaintiffs here?
So if you're talking about concrete substantive injury, I think we have said enough to make clear that there may be such harm. I will absolutely still insist there's no obligation for us to demonstrate at this juncture that there is harm. I will acknowledge, like other substantive issues and cases, there's a continuum between motions to dismiss and summary judgment and the like. And the law of standing is very clear that it gets reevaluated at different times in a case. And it may be that a remand is ordered and the district complies and they do an EISF or some preliminary assessment and they do enough to demonstrate that there is no harm and that at that point, everybody should be happy because there'll be no harm and our clients may not have standing at that point or the plaintiffs may not have standing, but procedures will have been met and we'll have at least a solid basis to understand why there's a record that a court is willing to affirm that says there's no substantive harm. But we're not there yet, Your Honor. And we do not have an obligation to demonstrate that there is substantive environmental harm. We have to demonstrate that there may be harm and that if there is harm, those plaintiffs are close enough that they would be impacted by it. And I think that has been met.
Okay. Unless there are any further questions from my colleagues, I think we'll hear from Mr. Barnes.
Thank you, Your Honor.
Thank you, counsel.
Thank you, Your Honors. Johnny Barnes is my name. I was counsel at the trial level. I will ask the court to allow me to reserve 4 minutes of my time for rebuttal. And principally to allow Mr. Jaffe an opportunity for further argument, because I think this case should be reversed on the issue of standing alone. I'm going to address the DC Human Rights Act violations. We did bring in fact, the trial judge said at the beginning of the hearing that he was going to find standing, and then he didn't. Environmental standing is, and I have to say this, is a discrete kind of standing. And since the Tennessee Valley case, Supreme Court stopped the construction of a $150 million dam to protect fish. They've stopped the construction of to protect spiders. And standing is almost automatic, the court said in Tennessee Valley Authority, which we brought to the court's attention. That was a centerpiece of our argument at the trial level. Standing is almost automatic in these environmental cases. And the judge said it himself, but he didn't do it. I want to address the DC Human Rights Act violations and point out that the DC Human Rights Act, which applies to the district government, protects where you live, your residence, what one's race is, race and color, and who one is, family responsibilities, familial status, source of income. It protects Black people who constitute, according to the EJ screen, which was done by the Environmental Protection Agency, 84% of those within the proximal area of this facility.
Well, counsel, I understand the protected traits, what area of civic life are you focusing this argument under? Are we looking at public accommodations? I saw housing lurking in there when I read the briefing. Where's your focus under the Human Rights Act?
Residence, race, and income.
No, I understand those as the traits. You may recall in reading our background, I was formerly an ALJ of the Commission on Human Rights and dealt extensively with this act.
So was I, Judge.
Thank you, Mr. Barnes. I'm aware of that too. And so under the four protected areas of life, we've got employment, educational institutions, housing, and public accommodations. Is your argument, is the thrust of it, that DC is somehow affecting the housing rights of the folks in the Brentwood area and Ward 5 generally with the historic discrimination you've described? Or is it that this is really about public accommodations and where DC chooses to place those and the impact of that on Ward 5?
Well, I think you just answered it, Judge, public accommodations, because half of the toxic facilities in Washington, DC are in Ward 5. And that wasn't the case back in 1948 when they had restrictive covenants, which didn't allow Black people to live in Brentwood. All white people lived there. And then the federal court lifted those restrictive covenants and the white people left and the Black people came in. And when the Black people came in, multitudinous toxic facilities came in with them. That's why half of the toxic facilities in Washington, DC are imposed on a community that's 84% Black now.
I think one of the district's responses to this argument is this new bus depot that you're challenging is really replacing two pre-existing bus depots, that it's not adding to the harm that you're alleging, that it's really just a tit for tat. What's your reaction to that?
Yeah, we've heard that argument before, Judge. And what they ought to do is find some other places to put some of these facilities instead of stacking them up. I was a lawyer that.
Well, I mean, I guess the reaction is we're not stacking them up. It's one in, one out. We're replacing what's already there, and we're not. So if you might, maybe there was a complaint when the initial bus depots went in, but now that they're replacing bus depots, there's not a new cause of action.
Why not look to other places, Judge? That's what they haven't done. Why not look west of the park? Why not look to more affluent areas? You don't find these toxic facilities there, and that's the harm. That's the public accommodations harm. That when you say we're going to protect you where you live or because of who you are, and then you don't do that, it's really a right without a remedy. It's really illusion.
So counsel, one of the arguments that DC was making, or some of the facts that they were positing said, it wasn't just tit for tat, one in, one out, but they were in fact consolidating two previous bus depots in Ward 5 into one. They were going to shrink the number of buses. And later after the initial decision, we're going to add electric buses too. And then also that we're going to be multiplying on-site parking and getting away from taking up as much street parking. If that reduces the harm that's already existent, does harm still lie in your view under the DC Human Rights Act?
Well, we have 14 experts in the District of Columbia's own health report said that the harm is not going to be reduced. It's going to be exacerbated. That when you bring in 250 buses, 500 vehicles where there's no parking already in the Brentwood area, you're going to increase the harm. And the expert sent that letter to the mayor, and that letter was ignored. The district did a one-day traffic study, and even the guy who did the traffic study said he wouldn't stand by it. Said that on the public record. And then before Judge Howard, the tanks were not discovered until after the judge ruled against us. And that's why that was not part of the argument at the trial level. Those toxic tanks, underground tanks, were not discovered until afterwards. So we had no reason to address it at the trial level. Now, I will also say that we had initiated discovery, Judge Stedman, and the district government simply failed and refused to respond to the discovery request that we had. We brought that up. It's in our brief as well. We brought that up before the trial judge, and he sort of poo-pooed that. But we were seeking information that would have been critical to our response to the government's motion to dismiss. That's why you have de novo review. This was dismissal. This wasn't even summary judgment. I think Ms. Shanefield, one of our experts, did a great job in mapping out the evolution of the toxic facilities in Brentwood once there was a change in the racial makeup. Now, the DC Human Rights Act sort of mirrors the enlightened thinking on discrimination since the case some time ago that stepped away from Arlington Heights, stepped away from this notion of strict scrutiny. And what it says is you look at impact, and it is a disparate impact on Black people and poor people when you put all of the toxic facilities, most of them, half of them, in their neighborhood. I was saying, Judge Deal, I was the lawyer that when they try to bring additional buses into Ivy City, which is right adjacent to
sounds to me like
Brentwood.
this is more of a zoning argument that you're making.
No, I don't. Well, we did raise the zoning issue as well.
I mean, that's the normal way in controlling what kinds of things can be done in what kinds of neighborhoods.
And the zoning law requires that there be consideration of the Environmental Policy Act. And see, the difference here is that the district government ignored the Environmental Policy Act until they discovered these underground tanks. And then in February of 2022, even though their own lawyers said they were going to start construction in December of 2021, in February of 2022, they started down this path that I'm not going to try. I'm going to let our environmental standing expert tell you why it's the kind of harm that's cognizable in the courts.
This is sort of a moving train, isn't it? I mean, the trial court makes its decision, when was it? February 2022. And now it's the spring of 2023, and the project is apparently almost finished.
No, it's not almost finished.
They
won't even tell us what they're doing, if anything, and they're supposed to. You know, one of the things I helped write the Home Rule Act, Judge. And one of the things Congress was very important to Congress, government in the sunshine amendment. And they won't even tell us where they are on the construction. We have to kind of guess. We know that they dug up those tanks. We know that. We don't know what they found. So it is a moving train. And I think Mr. Jaffe pointed that out. That's the nature of this environmental struggle. Sometimes that's why you stop it. That's why in Tennessee Valley, they stopped that $150 million construction project. This is a $20 million construction project. And the law also says if it's $1 million or more, you got to do those things that Mr. Jaffe talked about.
So what are you going to get from it, counsel? If we stop this, there's now been an EISF done. Is it that you want another EISF done, or what new things do they need to discover? Presumably they've taken control, not presumably, they've taken control of the site. They've done some stuff on there. That's where DC discovered the tanks. Well, what are we going to get out of this?
Well, I mean, we're going to get out of them doing what they're supposed to do under the law. I don't know that they've finished their EISF. I don't know that. We know they started February 2022. They won't tell us, and they're supposed to tell us stuff. And I think that's one of the things Mr. Jaffe was pointing out. Got to have public involvement. You've got people who are stone's throw, and in our appendix we have the pictures of all those things that are going on now. This would be a great opportunity to go out and look for yourselves There's so much junk within a stone's throw of the plaintiffs. And it's no wonder that they're facing cancer and asthma and all these health challenges as described by the experts. We put pictures in the appendix of what's going on now before the bus depot, right in the heart of Brentwood. And they want to pile it on. And I know, Judge Dill, they say they just want to move one and put it in Brentwood instead of having it over in Ivy City. But it's more than that. The magnitude of what they're proposing a training facility and they're proposing these buses are going to start rolling at 4 a.m. in the morning, rolling right in front of these homes of our plaintiffs every 40 seconds. And they will leave. They will come back in at 7 p.m. every 30 seconds until 7 p.m. every 30 seconds. You talk about harm. We protect fish and spiders and snails. We ought to protect people. And that's what this case is about. And that's what the Human Rights Act says, protect people. Our government isn't doing that. They simply are not. I said, they're like a bull in a china cabinet, just rushing through headlong to do what they want to do, irrespective of the law. They've broken the law, violated the law at many stages. And the Supreme Court said, when you do that, every federal court that heard the Tennessee Valley case said that, Judge Thiel, when you do that, we stop it. That's what we want, Judge Howard. Stop this construction until they've done what they're supposed to do, until there is some useful contest to the views of these 14 experts, lettered and learned experts. So you're going to be in trouble until the EJ screen has been rebutted, if they can rebut it. It says you're going to be in trouble if you put this bus depot in Brentwood.
All right, Mr. Barnes.
That's what
we've given
Human
you
Rights Act provides. Thank you.
We're
Judge.
giving you some extra time and we'll still give you 4 minutes on rebuttal unless
Thank
my
you.
colleagues have any additional questions. We will hear from Mr. Girton for the district.
Thank you, Your Honor. Good afternoon, and may it please the court. Jeremy Girton for the district. I wanted to start, if I could, with just correcting the record on a couple of points my friends on the other side made. The first couple were about timing. I think it was incorrectly described that the EISF was issued after the Superior Court's ruling, and that is not correct. It was prior to the court's preliminary injunction hearing and prior to the motion to dismiss briefing. It was actually attached by the plaintiffs in their opposition to the motion to dismiss as an exhibit. So it was available to the court at that time, and they never moved to amend their complaint to address any of the findings in the EISF. The second was on the discovery point, which was made at argument and in the reply brief. Mr. Barnes has suggested the district did not comply with discovery requests, which is not correct. The first round of discovery requests was never served on the district. The second round was served on the district and responded to prior to the motion to dismiss briefing on February 7th. So that was also available to them. And again, has never prompted a motion to amend the complaint. And then the third factual matter I just wanted to clear up was what Mr. Barnes just said about the buses traveling in front of residential neighborhoods. That is also not correct. The Superior Court found in its order on the motion to dismiss and in the preliminary injunction hearing that no buses would travel through residential neighborhoods as part of the plan. So I just wanted to clarify that for the court. And if I could start on the question of standing, I would like to address Judge Stedman's question about the procedural injury that amicus has raised. That was never presented to the Superior Court by the plaintiffs, and again, was not raised in their opening brief. And I think our understanding of the procedural injury requirement as described by this court in Tilden Park is that you still need, in addition to the procedural injury, what the court described as, quote, a demonstrably increased risk
of serious environmental harm. That's page 1211 of this court's decision in Tilden Park. That demonstrably increased risk to the environment is something that the plaintiffs have never alleged or put forward any evidence for. And I think that's where we have a problem with standing, is that they haven't, they've alleged a probabilistic harm, but they haven't identified what that probability is of that harm occurring. And that's, go ahead.
There's a big project underway, $20 million or something. These people live a third of a mile away. There's allegations that there's going to be more traffic. There's allegations that there's going to be a lot of noise. There's allegations of various kinds of ways in which the project will affect the neighborhood in an environmental sense. And I sort of, it seems to me that what we were trying to say in Tilden was that if you're dealing in the Supreme Court cases as well, if you're dealing with environmental kinds of objections, that you just don't have to have the same type of concrete harm that seems to apply in standing normally. And that perhaps it's enough to say that there's at least a potential for some kind of harm. Is that not kind of where you think we sit?
I would characterize it slightly differently, Your Honor. I think what the Supreme Court said in Lujan and what this court said in Friends of Tilden Park is you actually still need that concrete interest on behalf of the plaintiff. What Lujan said is that in environmental cases, you can relax the redressability prong of standing because you don't have to prove that had the study been done, that the government's decision would have been different. So you can kind of relax that prong of the inquiry. But I don't think it said you can relax the requirement of injury. You still need the concrete injury to the plaintiff. And you can show that through probabilities. I mean, that's the NRDC case talks about if you have a study or something that says.
Well, the problem is concrete sounds very concrete. And when you're talking about environment, it's a little hard to get your head around the fact of how concrete it has to be shown when what we're talking about is the environment. And if people are living in the environment and there's an act which says, hey, before you do things that are going to affect the environment, you have to follow certain steps which they claim were not met here. Isn't that enough to, I mean, why isn't it enough?
So it's not enough, Your Honor, and I think that that's been rejected both in the Lujan decision itself and in many decisions of this court in the DC Circuit, which is that it's not enough that there's some abstract injury to the environment, because then anybody in the country could, in theory, bring a claim if they would have standing. So what the court said in Lujan is you still need a concrete interest of the plaintiff that's connected to the environmental harm. And then that's been made clear in the DC Circuit's decisions. I would point the court to the Olmsted Falls case from the DC Circuit where it said geographic nexus is not enough. What you actually need to show is the not just proximity, but that it's related to the injury that the plaintiffs are alleging they're likely to suffer, and that that's tied to the project. So that's where we think we're
So
missing
the
that
plaintiffs
connection.
allege that. What defeats the concerns that they raised?
So I think
And actually, maybe I can be more direct for you and to help you answer the question. I'm actually pretty concerned now after hearing from Amicus and others. I get, and you heard me questioning before, DC did these studies ahead of time. And I know there's admittedly some shortfalls in the studies from the record that they admitted we can't really do a good traffic study because we're in a pandemic and traffic's not normal. And DC clearly thought it was serious enough to go into this process once they discovered the tanks. But, you know, if we look at the publicly available website that Amicus cited, the entry about the tanks was put in as a leaking tank area from and the company name that owned it, Crane Rental, was there since 1997. And this was somehow missed. It was serious enough to start that process, but we missed it at the outset. And we know that the traffic study wasn't necessarily perfect, and we could probably do some things to remedy that, but how do we trust all the other assumptions that led to saying, and I think you heard from my earlier questioning, and sorry, I'm giving you a whole speech here with it, hopefully, and I can break it down into individual questions if you want, but my concern was, did DC do what it needed to do? Did it determine that there was not a substantial risk of environmental impact, and so it didn't need to go through this process under the statute or the regulations? But if we can't trust the work that was done to start with, how can we find that? Is kind of the origination point for that question I originally asked you that I hope you still remember.
Thank you, Your Honor. I will do my best to answer it, but please correct me if I fail to answer Your Honor's question. I think the record is not clear on why no EISF was done originally, or why one was done after the project began. But my understanding was that initially the project was misclassified as being exempt from the entire EISF process. And once it was realized that that was an error, the EISF process began. And I think another aspect of the decision was that an EISF would require the kinds of studies that had already been done. The air quality and traffic studies had already been completed. So the substance of the EISF was already available to the public. It just was that additional form kind of that lays on top of it that was needing to be completed. And I acknowledge that the EISF identifies those underground tanks. Those have already been, as I understand it, removed and the soil remediated. So I'm not sure what injury to the plaintiffs could result from that already existing remediation. But the district didn't acquire title to this property until 2016. So to the extent another party owned the land and was not in compliance with some environmental law, that's not really an issue here.
But DC could have discovered that in 2016 based on it being reported as early as 1997, right?
I suppose in theory it could have discovered it earlier, but I think for our purposes, the tanks have already been removed. The soil's been remediated. That was overseen by DOE. So I don't think plaintiffs have ever alleged what injury that would cause them or what probability of injury that would cause.
Is the EISF done now completely?
So the EISF has been submitted. The process is kind of iterative with DOE. So I think one thing we identified in our brief is that an updated air quality study was done at DOE's direction. I believe a traffic study is also being done to kind of address the issues about the original study being done during the pandemic. So that process is kind of ongoing. I'm not aware of any plans to submit a new EISF, but the agencies.
Well, let's think about this for a moment. The government legislature says we're worried about the environment, and therefore for certain projects we're going to require that there be an environmental impact study to find out whether or not this project will or will not affect the environment. Now, it seems to me to be asking an awful lot to say that somebody to have standing has to come in and show that this project is going to have a concrete impact on them, when the whole purpose of the study, which they claim was not made, is to find out that very fact as to whether or not it will have impact. Now, as I understand it, the law says that there has to be an environmental impact study made if the project was over $1 million or something, and if there is a likelihood that the project will result in some environmental impact. Now, I don't know quite what to do with that word likely, as opposed to, you say, oh, possibility is not enough. It's got to be likely. But I just wonder whether or not in this record there isn't enough to show that, I don't know, is it likely or not? I don't really know. The problem, of course, is then you get into substance, not standing, but substance. Whether it's likely or not is a substantive question. You want to have evidence. What is going to happen? What could result from this kind of thing? And to incorporate that kind of thinking into a standing question is quite difficult for me to get a handle on. And that's why I'm in this argument. I'm trying to sort of get a sense of what the parties are saying here in the sense of the potential harm that is being alleged. And some of it sounds kind of an impact anyhow, enough, maybe.
So I want to answer Your Honor's question. I think it hits on something that's important. I think it's important to disaggregate the DC EPA claim on the 12B6 grounds from the standing analysis. I think they are two different inquiries, although related. But for DC EPA purposes, to allege a claim of a violation of the DC EPA's requirement that you have an environmental impact study, you need to allege that the project is likely to have a substantial negative impact on the environment. And our position is that no such substantial negative impact has even been suggested in the pleadings or in the briefs here. But that's a question kind of for 12B6 purposes. For standing purposes, I think you could, in theory, establish standing if you show that there was a probability that the project was going to cause some health-related risk or some other harm. But you need to articulate what that probability is, and you need to articulate what the ultimate harm is going to be. And I think that's where we're missing here. They've talked a lot about different things that could be an injury, like air quality, but they haven't actually said, that the project is going to produce some kind of pollutant, and that's going to create some probability of health risks to other people. So they haven't done any of that. And I think that's where we're having a problem with standing, is that when you base standing on a probability, you need to actually articulate what that probability is and what the ultimate harm is going to be.
One thing Mr. Jaffe said, which I take it you'll agree with, is that standing is really evaluated on a rolling basis. So at the motion to dismiss stage, they don't need to show that there's a likelihood of harm. They need to have stated a plausible claim of a likelihood of harm. And then when you get to motion for summary judgment stage, you can reevaluate that and say, well, would the evidence allow a trier of fact to draw that conclusion? And then when you get to the trial stage, there's a question of whether or not the probability has been substantiated. With that, do you agree with that general proposition?
I do, Your Honor. I think Lujan makes clear that the burden on the plaintiffs ratchets up as the case progresses toward trial, starting at the motion to dismiss stage. The one caveat I would note is that this court's precedents allow at a 12B1 motion to look outside the pleadings, and says that there is no presumption that the complaint is true when you're doing kind of a factual standing analysis. So I think that's slightly different than the way maybe Your Honor phrased it, but I do agree in general, that's how it works.
And if the claim is just this, look, this is a massive undertaking. There's already some soil contamination from these tanks. There's going to be a substantial number of additional buses that are running in the area. The kicking up dust alone in the area from the construction is going to be, detrimental to people's health. We would have to say that is not a plausible, that's implausible to find that there's no standing at a motion to dismiss stage. Why is that implausible?
So I think Your Honor's question presumed a lot of allegations that aren't actually in the complaint. The complaint doesn't contain any allegations that there are additional buses driving through a residential neighborhood. Doesn't contain any allegations.
Doesn't your own EISF that you guys entered into the record say there's an additional 86 bus trips in the afternoon?
So the traffic study examined the intersections around the proposed project site and said that would result in additional afternoon trips in the immediate area around the site. That's correct, Your Honor.
Okay,
but
and you would agree that we could take those into account. I mean, that it doesn't necessarily need to be in the complaint. You can look at the way that both the way the answers came in and any evidence the party submitted at the motion to dismiss stage in support of the complaint or in support of a motion to dismiss and assessing the record, right?
Yes, I think you can look at the additional information that's kind of undisputed by the parties and the additional information that's in the public record. The court can take judicial notice of that.
So counsel, as a sub point to that, when we're looking at that, do we look at that absolutely or comparatively? Is the point that overall 2 bus depots are going to get turned into one and there may be less buses and that's how we should look at it? Or are we looking at it when we're looking whether there should be an EIS and EISF, et cetera? Are we looking at the construction project on its own? purely that we are now in this new site going to have 250 buses, et cetera, and it's going to produce 250 buses worth of emissions, et cetera, until they go into electric?
So I think that it's possible, Your Honor, you could look at it either way. We have framed it as looking at the project as a whole, which is the transfer of one bus station half a mile down the road, and kind of, you know, the overall effects that will have on the community. Because I think that's how, frankly, plaintiffs have kind of framed this as talking about the effect on the overall neighborhood. But, you know, the traffic study and the air quality study, I think, kind of went from a baseline of no, they didn't discount the effects of closing the other bus depot, if I'm making sense there. So I think they looked at the air quality effects and the traffic effects, kind of assuming that there was no change to the other depot down the road.
Okay, that's good to know, because the next question was going to be, and I'll still pose it to you. If we looked at it comparatively, would we not just be perpetuating the historic discrimination that complainants, the appellants complaining of?
Well, I think that's a fair argument, Your Honor, but it's not one that's recognized by any of the claims that they've brought in this case. I think, you know, Your Honor posed some questions to my friend, Mr. Barnes, about what provisions of the DCHRA are really being implicated here. And I think his answer was that it was the public accommodation provision, but that really doesn't apply. This isn't a public accommodation that there would be a restriction on access to, for example, for local residents. So I just don't think there's any provision of law that they have brought to the court that would redress that kind of injury, kind of a historic discrimination, although certainly concerning, is not one that's redressed by the DC EPA or the DCHRA provision that applies to the district, or, you know, any of their other claims.
Would you agree that the bus service to children in the district is a public accommodation?
Certainly Aussie's operation of the buses is, but I don't think there's any allegation that these residents wouldn't have access to those services the same as everyone else.
But the allegation is that the residents are impacted by the placement of Aussie and of that facility and other toxic facilities that provide public accommodations predominantly in their wards. So I'm not saying whether that's right or wrong, but conceivably that's an argument they can make, right?
I suppose they could make that argument, Your Honor. I've never seen a case about public accommodations where the provision of a public accommodation, in this case to children with disabilities, would disproportionately impact a different group, and then that group would be able to bring a claim. I'm just not aware of any case like that. But in terms of how the DCHRA is structured, it talks about services provided by the district and denial of those services based on someone's race or another protected characteristic. And I don't think there's any allegation that that's what's happening here. So they're kind of trying to transform that into a broader disparate impact statute, which is just not the law that we are dealing with.
Can I just get an answer to my question of why you don't think in the complaint? I mean, when I look at the complaint, at page 10 in particular, and then perhaps the plaintiff's exhibit A, it seems to say that this Brentwood facility would result in a number of environmental impacts. They list, let's see, I see 8 bullet points there on page 10, including health impacts of pollution, degradation of air quality, prevalence of asthma, prevalence of cancer. They've got an exhibit A that, you know, I don't know how persuasive any of this is, but usually I'm not asking myself that question at a motion to dismiss stage. Usually I'm asking, well, have they said something plausible enough to get past the motion to dismiss stage and then let evidence come in? But I took your answer to be they're not really making those allegations. What do you have a reaction to page 10 and the exhibit A? Is that consistent with your position, and why do you think it is?
Yes, Your Honor. So I think what the issue we're having here is this is describing, as I understand it, the District of Columbia Health Equity Report, which is just kind of a separate analysis, not specific to this bus terminal. So I think what they're pointing to in this and many of their other arguments is historic inequities of this area, but they're not connecting any of those to a specific injury that's going to arise from construction of this terminal. So I think that's where we're missing. And you know, if you look at the expert letter, it talks a lot about, you know, it summarizes the findings of the EISF and the traffic study and the air quality study. And then it says, certain pollutants can cause, probabilities of other injuries, but it doesn't say the pollutants identified in those studies from the bus terminal are going to cause those harms. And that's kind of the disconnect we're having here. So just want to check and make sure I'd answered all of the court's questions. Unless the court has any further questions, the district would ask the court to affirm the judgment below on standing grounds or in the alternative on 12B6 grounds.
Thank you, counsel.
Well, if we rule against you on the standing issue, what next?
So our position is that the court could address the 12B6 arguments. Plaintiffs affirmatively brought them up in their opening brief, and the court could affirm on that alternative basis. One point I noted that amicus said in oral argument is that it is asking this court to direct the Superior Court to enter judgment in favor of plaintiffs, and that's really not an option on the table.
It's a possibility, but seems odd to do that when the trial court hasn't really ruled on the what you might call the substantive question,
right?
Failure to state a claim.
So I think the court,
which gets all mixed up with this standing issue. I mean, you come in and say things like, well, they haven't shown that the traffic really is going to be that bad. Well, isn't that a substantive question? Why is that a standing issue?
So
it really gets hard.
So I think what the standing doctrine requires is it depends on what the injury at issue is. And so if it's an actual injury, they need to allege what that actual injury is. In this case, they're saying it's a probability of harm to their health. I think that's the best way to characterize what their injuries boil down to, is that the construction of this depot will.
So what you're saying is that they haven't really alleged that this really is going to harm them in any way.
Right. That's correct.
They have to show exactly how it's going to harm them.
Not exactly, owner, but they need to allege.
Well, not exactly, but concretely.
A concrete injury of some kind. I think it's unclear from the complaint whether they think that the injury is to air quality or traffic or noise.
So maybe the question is, does the possibility of a likelihood of or possibility of harm, is that concrete or not? No, I guess not. That's your argument.
Yeah, our argument is that it's not concrete because as this court set out the standard in Tillman Park, a demonstrably increased risk of serious environmental harm. That's the standard they need to establish. So demonstrably increased risk, it can be of, a variety of harms, but they haven't really alleged what those harms would be or demonstrated that there's a probability that they're going to occur. And I think that's where the issue for standing purposes is. And I do recognize that that's different than the 12B6 issue. But that would be what we would say. The court should, just adhere to that precedent and say that this complaint doesn't contain any demonstration of that, nor to any kind of the other surrounding materials. Thank you, Your Honors.
Thank you, counsel. And we will give 4 minutes of rebuttal to, it looks like Mr. Jaffe. Mr. Jaffe, just let us know if you'll be splitting rebuttal time or if you're taking it all yourself.
I believe that Mr. Barnes is going to generously allow me the entirety.
Very good.
So I'd like to provide some brief further responses to some of the questions that the court asked Mr. Barnes, and then I'd like to respond to some of the issues that came up in the district's argument. So first, there were questions about what gets analyzed. I think Judge Howard was getting at this. One thing that we haven't really talked about here is the procedure for doing an environmental impact statement, because one of the cruxes of an environmental impact statement is the analysis of alternatives. One of the alternatives always is a no action alternative. So you're always going to look at just keep the existing bus terminal. But in this case, it's actually really interesting. And this may be the first case I've come across this. There's an alternative that makes things better, not just avoids making things worse. And that is, how about evaluating going to all electric buses? We're in a new world here. Everything's changing. There's all this federal money. Some of the stuff's not in the record, but again, I'm just talking about what sort of alternatives would be assessed. One alternative you could assess would be immediately going to an all electric bus depot. And to me, that makes a lot of sense, not doing the depot, but doing an assessment of that alternative. And who knows what you might find. And it goes back to what I spend most of my time on, what you folks have been interested in, which is, how do you really know the answers? This is another one from Judge Howard. How do you trust the studies that the district has done? And the answer is you trust them by knowing that the Environmental Policy Act was complied with and people went through the procedures so that there's public comment and there's enough opportunities for input that you can rely on them rather than having the district just do them independently outside of the required statutory process. I think that's really important. So when you say, what will we get? I think you asked Mr. Barnes, what will we get out of the traffic study and an air emissions modeling? What we'll get is something that we trust because it was done pursuant to the Environmental Policy Act. As to Tilden Park, it's always, we get to tell you what we think your cases say, but Tilden Park is a decision of this court. Ultimately, you get to decide it. I think Tilden Park is pretty clear that if there's a potential for harm, and there is a demonstrated procedural violation, then that's enough for standing. But you folks get to decide that. I want to talk briefly about the status of the cleanup and what's going on there. And once more, giving credit where credit is due, the question raised by Judge Howard. Again, not in the record, but I think you folks are kind of drawing this inference anyway. Nobody buys a piece of property in the world today, and certainly not in an urban area, without having what's called a phase 1 site assessment done. There's no way that the city didn't do some kind of assessment in 2016. So if the requirement to close a tank is within 1 year, if they didn't do a phase 1 site assessment when they bought the property, shame on them. If they did, they would know, they certainly would have known 6-7 years before the tanks were removed that they should have been looking at the tanks. As to how that impacts, what should be done now, I will confess, Your Honors, that's a hard one, because my concern is you can't just let people get away with this. Because again, as I said in my original argument, you're just providing a roadmap for people to avoid complying with the act. If you allow people to fix it later and there's no remedy, there has to be some kind of remedy. I think here I would focus on.
I mean, there was a remedy available. They could have sought injunctive relief before the building started if they thought an EISF or EIS was required, right?
Well, they did seek injunctive relief. They did not, I will confess, appeal the denial of injunctive relief to this court, but they did seek injunctive relief.
Right. Okay.
That's why I asked whether or not the argument was raised below. I mean, it seems to me what you're really saying now is the trial court erred in not granting a preliminary injunction because they had not at that time complied with the law. And it seems to me that it would have been pretty easy to issue a preliminary injunction if that.
I agree with that. And I would go further.
But it's too late now. I mean, you can't turn the clock back. You didn't appeal it. You didn't raise that argument. Why are we
can't
now
get it? We may not be
accepting
able to get a preliminary injunction. I'm sorry, I didn't mean to interrupt, Your Honor. Sure. Okay. But we could get an injunction to the extent that this project's not complete. And I don't think it's a crazy argument to say this court can remand with instructions to order compliance, because in fact, in my experience, most of these cases, appeals from final agency action on an administrative record go off on judgment on the pleadings, because the record is supposed to define everything. We have serious problems with the record here, and I'm not even going to attribute that to one side or the other, because they're just problems with the record, and I'll acknowledge that. But the record is enough to say, oh, there actually were procedural violations, and we know now that there's a level of proof of those violations that the trial court could order that without any further proceedings. I truly think the record is sufficient to find that there are violations. So to me, what needs to be done is a study that, air studies, traffic studies that are done within the context of the Environmental Policy Act and subject to the public comment and review under that act. If you don't have any other questions.
All right. Thank you, counsel. The case will be submitted and we'll take it under advisement, and the court will stand adjourned.
Oh,